Good afternoon and welcome to the Senate Judiciary Committee meeting of April 26, 2020. We're going to open the day by opening the public hearing on House Bill 1280 and recognize the prime sponsor, Representative Roy. Good afternoon, Representative.
Good afternoon, Senator and honorable members of the committee. I am Representative Terry Roy from Rockingham, District 32. I represent the towns of Candia, Deerfield, Northwood, and Nottingham. I'm here to introduce to you today HB 1280. HB 1280 is very simple. It would prohibit the termination of parental rights by the state for any parent who refused to have their child vaccinated. As far as I know, with some research and speaking to the courts, this has not yet happened. This is a prophylactic bill. About a year ago, in May, you may be aware, I sponsored an amendment to SB 155 in the House. And that amendment would have prohibited the termination of employees by private employers for refusing to get a vaccine. That bill lost on a vote of 193 to 182. And it lost based on the argument that this isn't happening and this isn't going to happen and no one's doing that. Well, here we are a year later and numerous people have lost their jobs because they refused to get the vaccination. So without getting into the pros or cons of vaccines or whether they're effective or ineffective, as a baseline principle, I'm proposing that the state should not be able to terminate the rights of a parent to be to their child for making a health decision that says, I do not want my child to get this vaccination. There are a plethora of other avenues that the state can use should it come to that, as far as dealing between the child's parent and the medical community and things of this nature. But one of them should not be taking their children away from them. And that's really all that this bill does. It's prophylactic. It hasn't been done yet. And I just want to make sure that it doesn't happen. And we thought a lot of things wouldn't ever happen that are happening. So I think that it's better that we're prepared rather than not. And that's all I have. If you have any questions, I'd be happy to take them.
Thank you very much for your testimony. Are there any questions for Representative Roy? Senator Whitley?
Thank you, Madam Chair. Thanks for taking my question. So do you know if it's happened in any other states?
I'm not aware. I couldn't honestly say, no.
Great, thanks.
Are there any other questions? Representative, I have a question. I thought I heard you say that it's happened here.
No, I was referring to SB 155, the amendment from last year,
Okay.
where the argument was that no one's trying to fire anyone for not getting a vaccine passport.
Okay. Thank you for answering that. The other question I have is, I'm looking at the bolded type where it says a parent's decision not to have their child vaccinated pursuant to an order of the state or federal government. I think that that's having the federal government in there because, of course, we can't tell them what to do. If they're going to issue the order, we don't have the ability to nullify it because of supremacy, which is written in our federal constitution. So have you thought about removing the words or federal government?
I thought about that when the bill was written. The federal government doesn't take children away, the state does. So the federal government may issue an order of some type, an executive order, even a law that says your child has to have this vaccination. We, as the state of New Hampshire, have the ability to say we are not going to take children from parents based on your rule or regulation. Supremacy would come into effect if the federal government tried of their own volition to take a child away from a parent. But normally that's done by the state. I'm not unaware, except for in immigration cases where the federal government would separate parents from their children. That's normally always done by the state. So if we remove the federal government portion and an executive order from the federal government where that your child has to be vaccinated, we wouldn't be able to say no to this bill. Wouldn't be able to stop that because it would only stop state orders to take. Do you follow?
Mr. Lehman, do you have a
Yeah, I have a
comment?
question about the ways the bill is drafted, because I
Yeah.
think it's drafted in a way that doesn't capture your intention. The amended language would be limited only to the state using the parent's decision in the very limited circumstance in which the federal government or the state mandated or ordered it. Is it your intention that the parent's decision not to have their child vaccinated ever be used as grounds, or only in the limited circumstance when there's an order of the state or federal government requiring vaccination?
That's a good question. I hadn't contemplated any other grounds. If there are other grounds that a vaccination could be used, then I would want it all encompassing. So I would be open to helping or with any amendments. As you know, it's your bill now.
Okay, thank you. Are there any further questions? Okay, seeing none. Thank you very much, Representative.
Thank you for your time.
The chair will call Representative Josh Keller.
Thank you, Senators. For the record, my name is Joshua Keller from Rockingham 33, District Fremont, Danville, and Brentwood. And I am on Children and Family Law, which heard this bill in the House, and I just wanted to give some thoughts from that hearing. There was someone that previously worked for DHHS a while ago, and they said that they knew someone which didn't have their rights terminated, but did have their children taken to a group home temporarily for their hesitation regarding vaccination because their a previous child had come down with Down syndrome, and so that they wanted to go with a different schedule. And also the issue that was just brought up pursuant to the order of the state or federal government, that was not brought up in the committee. And the intention, it seemed from the committee and the sponsor, was that it just not be considered as when DHHS is deciding whether or not to take a child, is not to consider whether or not the parents' decisions on vaccine status of their children. And so so this is only kind of a guidance, I think, to our current DHHS or our DHHS in New Hampshire. So
Okay.
that's all my thoughts.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much, Representative.
Thank you.
The chair will call Representative Timothy Horrigan.
Thank you very much. I'm Representative Timothy Horrigan, representing Stratford County District 6, the towns of Durham and Madbury. So I'd like to speak hopefully very briefly in opposition to this bill. I think it is in the same paragraph of the law books as an exemption, which I guess is designed primarily for Christian scientists, but that's Christian Science, even though it may not be the most effective means of medical care, is like, that is an established means of medical care, whereas the anti-vaxxer, you can just opt out of any vaccine you want. It's written, and I guess this may be by design, very broadly. This, of course, is in the context of the COVID-19 pandemic, and the vaccines have been very effective, but not 100% so. They've been very safe, but not 100% so. And I think, at least in certain quarters, I think the problems of the vaccine have been greatly overblown. Like, we can't overlook the fact that it's a respiratory virus that I think we've gone over the 1 million death mark here in the USA. If not, we will soon. And that's, just vastly larger than any of the effects that people worked up about. But I'd be opposed even if that was strictly limited to the COVID vaccine, because this takes in all of them, small, all the way, measles, the mumps, all the way down to smallpox. So they could opt out of any vaccine with that as the intent. And certainly terminating the parental relationship is a very drastic step. It doesn't just terminate the parental rights, it also terminates parental responsibility. So I don't think, I don't think there's any danger that the state is going to, terminate the parental rights of every parent whose children haven't gotten the COVID vaccine, because that would just be just immensely costly, and then they would have, the state might end up like having to care for all those children. So I don't think that's, if that's the reasoning behind it, I think that's an unrealistic fear. And if it, so I just think, I think it goes too far, and it's certainly the COVID vaccine and most of the other childhood vaccines. It's really reckless not to vaccinate your children if you have the chance, even though some families are going to opt not to. But like, we want to encourage as many people as possible to get their children vaccinated. So I think this is and of course, as we just heard, there's problems with the ways the bill is written. So my feeling is the best thing to do is just pull the plug on it, find it inexpedient to legislate. I mean, it will undoubtedly come back in some form next year, but I don't think there's any value in trying to fix it this year. So that's so I quickly come in and just express my opposition to it. So
Thank you very much, Representative.
Thank you.
Are there any questions for Representative Horrigan? Seeing none, thank you.
all right, thank you. Thanks.
The chair will call Chow Kelly. Good afternoon, Ms. Kelly.
Good afternoon. Thank you for allowing me the time to speak.
Would you move closer into the microphone and identify yourself for the record, please?
Sure.
Thank you.
Yeah, my name is Chow Kelly from Hooksett, New Hampshire, and I'm here to support this bill because the parents give birth to the children, not the state. So it's not up to the state to severe to cut that tie between the parents and the child. That is natural. So, I mean, from my personal experience, when I was moved around, when I was a child, I had to be separated from my mom for a short period of time. I suffer anxiety, and I still suffer to this day. You know, it's affect the child a lot, psychological and emotional, and it could last their lifetime. So the HHS is supposed to be there for the child's best interest. And, you know, just because of vaccine and take the kid away abruptly from the parents, that causing more harm to the child's life than helping. And in addition, this vaccine, COVID vaccine or any other vaccine, the body of the child belongs to the parent, not the state. It's up to the parents to decide what's best for the child to be injected in there, not what the law tells people what to be injected in there. My body doesn't do well with any Western medication at all. I have to use herbal medication. I get very sick when I have these pills. So not everybody does the same way. So the parents know their child best. So if the parents refuse to have the child get any kind of vaccination, we should respect that. It's none of the state business. Never mind taking the child away from the child, from the parents. So it's very simple and very common sense. So thank you very much for listening. We appreciate it.
Thank you very much for your testimony, Ms. Kelly. Are
Thank
there
you.
any other, are there any questions from the committee?
Thank
Seeing
you.
none, thank you.
Thank you.
Are there any other members of the public that would like to speak to House Bill 1280? Okay, seeing none, we'll close the public hearing and the committee will be in recess until 1:30. Yeah, we got a few minutes. The committee will come out of recess, and we're going to open the public hearing on House Bill 1382. Is Representative Kofalt here? Okay, you didn't remember when you come in, you have to sign up on this sheet, okay? So, yep, not a problem. Make sure you identify yourself for the record, please.
Thank you, Madam Chairwoman, and thank you to members of the committee for hearing my testimony. For the record, my name is Jim Kofalt. I represent Hillsborough County District 4, which is comprised of the towns of Wilton, Lineborough, Greenville, and Francistown. Several years ago, I was introduced to an organization here in New Hampshire that aims to promote co-parenting for separated and divorced couples. And their website featured a picture of a young girl wearing a t-shirt with a big heart emblazoned on it and the phrase, "My mommy and daddy both love me." That, to me, really captures the essence of what shared parenting should be about. Incidentally, you may be hearing from one of the co-founders of that organization in a few minutes. But essentially, shared parenting is a situation when both parents play a substantially equal role in their children's lives, and we recognize that that is in the best interest of children. Unfortunately, the scenario I just described is not always possible. I have also heard stories about children whose parents are effectively using them as pawns. They're engaged in an ongoing fight to determine who's going to be the winner and loser in a post-divorce relationship. And inevitably, the kids end up being losers. While our family courts can't force people to choose between the first scenario and the second, there are some proven measures that can be taken to make sure that everything moves in the right direction. And the right direction is fundamentally what is in the best interests of the children. To date, there are 6 states that have passed shared parenting legislation, acknowledging the primary importance of a substantially equal role for both parents in the welfare of a child. The National Parents Organization puts out an annual report card on shared parenting. Currently, New Hampshire is one of 9 states to get an F rating from the NPO. And fundamentally, that's because New Hampshire lacks a sufficiently prescriptive approach to allocating parental time. House Bill 1382, as amended by the House, offers a simple and very practical approach to addressing this. Number one, it defines shared parenting as substantially equal participation in decisions and substantially equal time with the child with a minimum floor of 35% for each parent. What House Bill 1382 does not do is eliminate judicial discretion with respect to factors that might contraindicate shared parenting. So if there is domestic violence, child abuse, or ongoing addiction, for example, the family courts would continue to have complete discretion to order parenting plans that do not line up with the shared parenting model. With respect to domestic violence in particular, there is evidence that when shared parenting is the default presumption, incidents of domestic violence actually decrease. I have provided, along with my testimony, an article about the effects of the shared parenting bill in Kentucky on domestic violence cases in that state. When there's no battle to be waged over what the parenting plan looks like, it has the effect of de-escalating conflict. This is not a left versus right issue. In fact, on the National Parenting Organization scorecard, there is one state that comes out at the top with an A rating, and that is California. There are a handful of states that have A- ratings, including Kentucky, Arizona, Wisconsin, and Florida. This is also not a so-called father's rights bill per se, it's a parents' rights bill. I've heard from a number of women who have been increasingly cut out of their children's lives because their ex-husband or ex-boyfriend had more money and better attorneys and more staying power in court. The fact that New Hampshire lacks a prescriptive approach to substantially equal parenting time leads to an environment where the capacity to litigate ultimately determines who, quote unquote, wins in the end. And as I said before, the children are inevitably losers in that scenario. The bill before you is a vastly simplified version of what was initially introduced. There has been some considerable discussion as to whether the bill, which stipulates at least 35%, adequately serves the principle of equal parenting. Although I would like to see the bill reflect a number that is more in line with the 50-50 approach, my strongest preference is that we take the important first step of establishing shared parenting as the primary factor determining what is in the best interests of children. You'll hear testimony today on both sides of that particular argument, but there is broad consensus that whichever number this committee chooses to go with, the time is right for New Hampshire to adopt shared parenting as a default presumption. That concludes my testimony, and I'll take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Representative Josh Keller.
Thank you, Madam Chair, and members of the committee. For the record, my name is Joshua Keller, Rockingham 33, the towns of Fremont, Danville, and Brentwood. I am a member of the Children and Family Law Committee, which heard this bill, and I just wanted to give some perspective from that vantage, I guess. I think that this bill does not have anything to do with parents that already have an agreement. This does not come into play. This is where the judge is finding what is the parental responsibility in cases where they're not able to agree, and the judge already in current law is allowed to conclude that contact between a child and both parents is not in the best interest of the child. And so this presumption comes after that. If they didn't make that finding, then the evidence shows that having a substantial relationship with both parents is really in the best interest of the child. And so one of the reasons why we didn't go directly to 50% is 50% doesn't leave a lot of wiggle room for that judge to decide, okay, 50% isn't really appropriate in this situation. And so that at least 35% was viewed as giving substantial opportunity to have a relationship with both of the parents without hemming in the judge too much as far as what would be the presumption as far as time with each parent. And so it tried to make it clear that we wanted to encourage the judge to make opportunities for those kids to have a relationship with both parents when it was appropriate. And so I believe that this language does that, and I hope that the committee will support it. And I'm happy to take any questions if you have any.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator French.
Thank you, Madam Chair. Thank you for your testimony today.
Yes.
So this 35%, so I understand the part if the court doesn't find that they shouldn't have contact with the parent, they won't. And if they don't find that, then it is presumed that they should have contact with both. So, but the 35%, is that written in stone? It has to be at least 35%, or can the parents come to an agreement on another amount? So it's less, say.
Thank you for the question. So these are examples of where they're not already in agreement, but in addition to that, the 35% is not a strict rule. Under line 11, it just says that there should be a presumption that shared parenting is in the best interest, you could always challenge that presumption in court and say that this is inappropriate.
Okay. Okay, thanks.
Absolutely.
Senator Khan?
Yeah, thank you for testimony. I guess I'm wondering that if we're defining shared parenting as the goal, why the 35% is used as opposed to a 50%?
Thank you for the question. So as I stated in my testimony, the feeling that 50% was a little bit too limiting to the judge as far as the flexibility and for making the rights and responsibilities of the parents, and that they wouldn't have to that the judge can make a 35-65 parenting plan without having the parents show some evidence that would overrule this presumption. So they would be able to have some flexibility there, in that we didn't believe, or at least I don't believe, is inappropriate for that flexibility for the judge to have. I mean, obviously, it's better if the parents have an equal amount of time, but that's not always feasible. And so we wanted to make the judge have as much flexibility within this kind of framework as possible. Thank you for the question.
Are there any further questions? Senator French?
Thank you. Getting back to that same line for decision-making responsibility, how does that take place? I mean, you have two people raising a child, they live separate. What happens if they don't agree and they have equal responsibility? Who has the final say? And I was just thinking, like,
So if they disagree?
yeah, if it was me and say Senator Khan, we might not agree on much, even though we're friends. So who would have the final say in the child's, and what's going to happen with the child for important decision-making processes?
So right now, there are many cases where people have equal role in decision-making process. We'll have a bill a little bit later regarding that. But if they disagree and they both have equal, then nothing would be able to be decided until they make an agreement. Or they would not be able to move forward with anything.
So, follow up? So if it was over vaccinations,
Sure.
I didn't want my child to be vaccinated, but my ex-partner did, then I would win because we wouldn't agree and the child would not be vaccinated. Is that what you're saying?
I believe you would have to go to court, and that would be decided there.
Okay.
I'm not,
I'm just trying to
yes.
follow this. Thank you.
absolutely.
Okay, are there any further questions? I'm seeing none. Thank you very much,
Thank you.
Representative. The chair will call Representative Lisa Post. You have to turn the microphone on. And I'm going to ask you if you have written testimony.
I do, and I turned it into the clerk.
Okay, so I'm going to ask you not to read it. We will have time this afternoon to read your testimony, so if you can paraphrase it,
Okay,
that would be very helpful.
thank you.
Thank you.
My name is Lisa Post, and I'm a representative from Hillsborough District 4, which covers Wilton, Greenville, Francistown, and Lineborough. I thank you, Madam Chair, for the opportunity to speak here today, and I appreciate the committee hearing my testimony on HB 1382. I ask for your support on House Bill HB 1382. This is an opportunity for New Hampshire to pass historic legislation to help the families in New Hampshire have a better life with both parents. Recently, last weekend at the annual meeting of the GOP, we passed a platform amendment that said we believe that it is in the children's best interest to have a substantial relationship with each parent, and the government should only interfere with that relationship with just cause. Well, HB 1382 passed out of the House with a 3565 shared parenting amendment. The original goal for this bill was for 50-50, starting with that presumption that would providing that clear and convincing evidence of the absence of neglect and abuse. Well, 3565 is an incremental step in the right direction. Supporting 50-50 shared responsibility will allow both parents participation in their children's everyday care and life. I'm one of 5 children. 3 of my siblings went through a divorce. The pain and despair that fractured the family was deep. It took many years for relationships to heal. Some did not. As an adult, I know the pain of a broken family, separation, and divorce can rip apart a family when there is not equal time for each parent to participate in their children's lives, especially if one parent has been disenfranchised entirely from that child's life. It's not the loss of a parent that the children suffer from. It's not the loss of a parent that only the children suffer from. They also suffer from connections with their entire family unit. Grandparents, aunts, uncles, cousins, all these things create anxiety, depression, and create the ability for the child to struggle with life events. Research provides overwhelming evidence that when parents are living apart, children generally do best when they have both parents in their lives. Similar legislation has been provided in previous years and has not passed. Our children are our future, and we need to provide legislation that would allow them to grow up with both parents participating as much as possible in their daily lives. And I believe that starts with the 50-50 shared parenting assumption. While in previous testimony, I did hear that 3565 was considered for the judges to have more leeway. Actually, 50-50 would provide more leeway for the judges to have room. And again, without any chance that there is abuse or neglect in that family. So although I want this legislation passed, I do not want to wait another year. I do not want families to have to wait another year. I've heard testimony from other people that said it's been 10 years that they've been trying to get this through. I'd love to see this get through, but I would even more appreciate it that if we could get it through with 50-50 and provide families an opportunity to be a real family even though they're fractured. That's the end of my testimony. I'll take any questions if you have them.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you very much.
The chair will call Keith Kuning. Oh, you didn't want to testify. Okay, Pamela Kiley. Okay, at this point, I'm going to ask people again, if you have written testimony, please do not read it. You can definitely pass it into our secretary, Jenny. I'm just going to ask you all to paraphrase. We will have some time this afternoon to read your written testimony. Thank you.
Yeah. Good afternoon, Madam Chair and members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence, which is the umbrella organization for our 12 community-based crisis centers that serve about 15,000 victims of domestic and sexual violence each year. The coalition is in strong opposition to HB 1382, which would establish a presumption of shared parenting, as you've heard so far today. And we feel that if this bill passed, it would be a huge deviation from the best practice that is in current law under RSA 461A, and will result in outcomes that are harmful and dangerous to victims of domestic violence and their children. The current statute was revised just a few years ago with the support of over 20 child protection professionals and community stakeholders, with the understanding that we should be applying every measure possible to ensure that decisions are made in the best interest of the child, and that judges have discretion in these cases, because as we know, there is no one-size-fits-all approach to every family. Instead, this bill moves away from that best practice and would impose a shared parenting in situations where it absolutely cannot work and would actually be detrimental to the well-being of the child. You know, shared parenting can be possible in the majority of cases in New Hampshire, and reflects a scenario where their cases are resolved without litigation or court intervention. However, this bill would actually only exacerbate those high conflict cases and increase the risk of violence in abusive relationships. It also would have an impact on adverse childhood experiences, or ACEs, because we know that long-term witnessing and exposure to domestic violence would have long-term implications on the health and physical safety of children in their upbringing. So essentially, we just really want to reiterate that this bill would actually have the adverse effect to improving the well-being of children. And really, it's important that judges have the ability to tailor outcomes in parenting schedules to the specific needs of a child, and that would work really in the best interest for the specific family in their unique case. So we really ask the committee to oppose this legislation and maintain the current standard, which really is in the best interest of the child.
Thank you very much for your testimony. Are there any questions from the committee? Let's see. Oh, Senator Khan.
Sorry, and thanks for being here. The best interest of the child, does that presume any kind of percentage allocation?
No, it does not. Thank you for the question. And I think it's already very clear in current law that New Hampshire finds that children do best when they have meaningful and stable contact with those parents, but only when it wouldn't be detrimental. So this would really put that blanket assumption that it is always in the best interest of the child to have that frequent contact, when we know that it is really important that all of those considerations be really thought through before making that determination.
And that is what the judge is empowered to do, is to think that process through, that final decision through.
Yeah, and there are family law practitioners here today that can also speak, I think, a little bit more to that practice. But I think it's just really critical that there not be something imposed on families from the beginning, because that would automatically negate the best interest of the child. It puts emphasis on shared parenting over the considerations that need to be made in each case.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
The chair will call Marilyn Mahoney.
Good afternoon. Thank you. Thank you very much for allowing me to testify. And I'm testifying in opposition to this bill. 20 years ago or so, I had the honor of being a member of the Family Law Task Force that was appointed by this legislature. And it was made up of a group of family law professionals that after a year of hearing and who met regularly, took testimony, did research. And after a year of hearings and meetings and research done by nationally recognized, highly qualified experts and hard thinking, developed what is now RSA 461A, which is the statute about parenting rights and responsibilities. It recognized and then became the law of New Hampshire that the importance of both parents' role in their children's lives. So since 2005, what you're now being asked to recognize as something new, it's been in the law for over 15 years. I asked to be distributed the statement of purpose from that statute. Not to be presumptuous, but if you haven't looked at that in a while, I hadn't. And I went back in preparation for today and looked at it. And you'll see what it says. Because children do best when both parents have a stable and meaningful involvement in their lives. It is the policy of the state, unless it is clearly shown that in a particular case it is detrimental to a child, to support frequent and continuing contact between each child and both parents. There's no math in there. Just support frequent and continuing contact. And to encourage parents to share in the rights and responsibilities of raising their children after the parents have separated or divorced. And then it goes on. So what I'm hearing people testifying as to the purpose of this bill was accomplished 15 years ago. What are we really talking about here? Well, for the most part, most parents are really good parents. But what we have to recognize is that not all parents are equally equipped or prepared to carry out the necessary and important tasks of parenting. And perhaps most importantly, it recognized that in this bill at the 461A recognizes that in homes where there is violence, the harm to the children from having witnessed or worse experienced that violence must be recognized, and those children must be protected. New Hampshire's families are not cookie cutters. There is no one size fits all. That's what this bill wants to do. I would submit that while most parents are fundamentally good parents, there are undeniably bad parents. Only need to watch the news lately to learn about how bad some parents are. And so our laws must ensure that the focus continues to be, as it has been for at least 50 years, on what is best for the children, for their health, for their safety, what is in their best interests. That is what must be first and foremost in our laws, not parents' rights. Parents have plenty of rights, but first we have to look at what's best for the children. It's been the law of New Hampshire for a long time. I'm saying 50 years, but probably even longer than that. I'm just not old enough to know. In House Bill 1382 does away with the best interests of the child standard. It replaces it with this notion that all parents, without any distinction or variation, must have to have some sort of sacred right, regardless of any given parent's physical location, mental or physical health, sobriety or lack thereof, incarceration, propensity to violence, or then even fundamental basic parenting skills. To be sure, the vast majority of parents are good parents, and indeed the vast majority of parents do have a shared parenting arrangement. Current law is that all parents have shared decision-making responsibility. There's a presumption of shared decision-making responsibility. That can be rebutted, but in answer to Senator French's question earlier,
Doctor.
the issue arises frequently that you'll have two parents who disagree about a decision. And when that happens, the best interest of the child must dictate by going to court, and the court will make orders. It's not unheard of that the court will give one parent authority to make decisions on a certain topic. It's usually very limited. But yeah, there's going to be log jams where you just can't reach a decision together. The court retains that power to make that authority, or give that authority to one parent or the other based on what's in the best interests of the child. Let's keep in mind that these parenting orders or agreements are in effect potentially for 17 years or a little more. During that period of time, and that would be obviously the max, from the time of infancy until they reach the age of 18. During that period of time, children obviously grow. They develop, they change, they learn. And so the parenting plan must also be able to grow, develop, and change along with them. So when you have a situation, for example, like a nursing mother who has an infant who should not be separated from that mother for more than a few hours, not just nutritionally, but physically, so that healthy bonding can occur. What happens then is that the court may order shorter but more frequent visits for the other parent. A special needs child who requires consistent and constant care and supervision, sometimes highly trained for one parent, we have to look at that child's needs. Parents who do not live within, say, a half hour of each other. Again, young children do not benefit from spending long hours commuting from one parent's home to another. That has to be able to be addressed. We have children who have parents who are incarcerated. There's nothing in this bill that makes an exception for those situations. The children of a parent who has been abusive to the other parent or to the children. Again, I don't see any reference to that. And also, you have the issue of the preference of a mature child. Once you get to be a teenager, kids have a voice. They should have a voice, not the deciding voice, but that has to be heard as well. These situations are real. They occur all the time. They cannot be overlooked or subsumed into the group of parents who are good parents and will always just make the right decision. The imposition of some sort of mathematical calculation like 35%, as far as I can tell, it's entirely arbitrary and capricious. It isn't based on any kind of reality. So it's better to stick to the current standard, which is equal or approximately equal. I believe that the committee members have received written testimony from Dr. Joanne Linden, and I'd ask that you please pay attention to her. I know you pay attention to everybody's testimony. Mm-hmm. I believe she told me she was going to email it to the committee members, and I hope that's happened. If it hasn't, please let me know and I'll make sure that it does. But she does a review of some of the important research that's been done. Her research that she cites is research. She cites who's done it, what the sources are, not just some vague, researchers have said. And the conclusion that she reaches supports what I've been saying, which is that, and what you've heard already in opposition to this bill, which is that what is best for children is for there to be no conflict between the parents. What is best for children is to have frequent and ongoing contact, but based upon what is in that given child's best interests. We achieve that by encouraging mediation, by rejecting violence in the family, and by recognizing that when parental cooperation and involvement is working well for the children, that is an indication of shared parenting. But when it's absent, then there must be some other arrangement based upon what's best for the child. Please, I ask you to continue the long and well-established standard of keeping first and foremost in our parenting law the concept that the parenting schedules must be based on what's in the child's best interests. Thank you very much.
Thank you for your testimony. Are there any questions? Senator French?
Thank you, Madam Chair. Thanks for your testimony. According to this, if this were to pass, if the courts find that continued contact between the parents and the children is the right thing to do, they have to declare, it's presumed that they will do a shared parenting. And then we go up to shared parenting definition, which means equal role in decision-making and a minimum of 35% at both households, correct? So it ties the court's hands to those minimum requirements, 35% and shared decision-making, is that right? According to this?
As I understand this bill, the court has to presume first that that is what should happen. So it puts the burden on a parent who disagrees with that to show and establish not what's in the child's best interest, but that somehow that wouldn't be workable. But the issue, I most often think of the situation where one parent lives anywhere more than an hour away. And how do you achieve, they may be a perfectly good parent, but how do you achieve a 35% parenting time without that child's life being utterly disrupted?
Well, follow up. And that's the problem I was having with this, because I'm doing the math and I'm going, okay, so they'll be with my ex-wife Monday through Friday afternoon while they're at school, and then I'll have them every Friday night through Sunday night. So they'll never stay with their other parent during the weekends ever to achieve that 35%.
And for some families that may work. For other families, what does it do to, for example, kids with extracurricular activities on the weekends? Or other, you can't imagine all of those situations. You've got to look at each, you can. It's beyond my imagination, so. I mean, there's just so many different families and so many different circumstances.
Yeah. Okay, thank you.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Stephanie Bray.
Thank you, Madam Chair and members of the committee. I have written testimony, which I will not read. And I also will not repeat what has been very ably said by Ms. Keelig and Attorney Mahoney. So, Justice Project that says what I'm going to say, but with a lot more footnotes. My name is Stephanie Bray, and I work at New Hampshire Legal Assistance. We take cases. We have a team of very dedicated attorneys and advocates who take very difficult cases for victims and survivors of domestic violence. We represent them in their quest to obtain protective orders, and we represent them in their quest to deal with the family law aftermath that follows. And we are opposed to this bill. The statute as it currently exists already has an entire package devoted to determining what is in the best interest of kids in separating families. And that package already includes frequent and continuing contact with both parents, the family's safety, particularly if there's abuse, the capacity of both parents to be supportive, and In particular, the package already includes giving the court wide discretion to make individualized, not cookie cutter decisions and parenting plans. That system works. The bill that we're reviewing today would start the needle with a number, whether it's 35 or 50, and that number supposedly represents what is fair for the parents. The problem that we see with that in our work in representing survivors of domestic violence is that on average, it takes a domestic violence survivor 7 tries to leave an abusive relationship. And one of the barriers that keeps that average up there is the following threat. If you leave, I'm taking the kids. Now, if the jumping off point when you arrive in the family division is a 50-50 split or some split that involves a number, what incentive is there for that person experiencing domestic violence to leave? The victim will say, I might as well stay in this relationship so that I can protect my kids 100% of the time, instead of, if I leave, the law will presume that they should be with the other parent, with the abuser, 50% or 35% of the time. This puts too high a burden on the victim, and it will keep that 7 time to leave average up there and perhaps increasing. And that's not in the best interest of children at all. So I'm happy to answer any questions.
No, I'm one.
Thank you very much for your testimony.
Thank you.
Is it Ed Brian's? Ed, there you go. Brian's, okay. Nice to see you this afternoon.
Thank you. It's nice to be here. It's several faces, so thank you guys for your service to our state. Sorry, has our chair left? That we continue? My name is Ed Bryans. I'm from Marlborough, New Hampshire, Cheshire County. Senator Khan is my representative. Thank you, sir. I am here to speak in favor of the bill. I believe, and frankly, I was a person that used the system. The current system is an adversarial system. It's a winner-take-all system. 10 years ago, I went through a situation where I had to, it was immediately told to me, point out all the dirt on your now former partner, because whoever can throw the most dirt that sticks is the other will walk away with the primary custody. It took 2 years in litigation that I was not able to spend time with my child. When I did get the day in court, I walked out with 50-50 custody. Since having 50-50 custody, my child has flourished. She was 3 years old. She's currently 13 years old. She's here with us today. They're on school vacation. She's the basketball team captain. She ran for and became the school president. She gets involved in a lot of civic activities. Her mother is more organized and mainstream, whereas I'm maybe a little bit more of an adventurer. My daughter loves sports. She's the best of both of us, and that's because both of us have an equal influence in her life. I've listened to some testimony. I won't repeat things that have already been said, but what I understand about this bill is it is a presumption that both parents are fit. There's a key word in there. It's rebuttable. The judge has the ability to look at all the circumstances and determine, and with, I believe there's 9 criteria that have to be fulfilled. The judge must put in writing why he's deviating from a 50-50, or in the situation as it's amended, 35% plan. I believe in 50-50. I do understand, as someone brought up, Perhaps an issue is travel distance. I mean, that would be very difficult to drive a child for a couple hours. But we have to weigh, is that inconvenience worth pushing a parent out of their life? Just a little bit about myself. For almost a decade, I am the administrator for Americans for Equal Shared Parenting in the New Hampshire division. I currently am on the board of directors for Monadnock Peer Support, which is in Keene, New Hampshire. It's a peer support agency. I co-facilitate a co-parenting group. Frankly, it's a partnership. There's myself and a woman, so we give both perspectives to parenting, both mothers and fathers. I've worked very closely with an agency here in New Hampshire, Time to Put Kids First, that does a lot of co-parenting training. So this has become a passion. I believe if this bill and when this bill passes, there's undisputable peer-reviewed experts agree that shared parenting is in the best interest of children. What nobody has talked about is the statistics of children that are suicidal, that are incarcerated, that have substance abuse issues. It's in the 80th percentile. These are children growing up with one parent. In my opinion, the standard hearing a lot of times is it's an every other weekend court order. If somebody's a fit parent, why only 4 days a month? That doesn't make them a parent, that makes them a visitor. 9 days a month allows that person to be a parent and have an influence in their child. I would love to see it equal, but I understand there may be circumstances that may not make that possible. Just to let the committee know, I've spoke with our Education Commissioner, Frank Edelblut, just last week. He's a former sponsor of this very similar bill. Frank, in his position, or the commissioner in his position, of seeing the problems that are in our schools, the commissioner absolutely supports this bill. And if it was to go to the governor's desk, Frank will be making a personal phone call. I sit here, my daughter is here. I didn't bring her up here with me. If anybody would like to ask a question of a child who is in a co-parenting 50-50 relationship, I think that's something that hasn't been asked of this committee. If anybody would like that. Anybody like to ask me any questions, I'd be happy to answer them.
Thank you. What was your arrangement prior to your court battle and winning your court battle for 50-50?
I'll make it short, Senator. Thank you. The divorce was filed. A lawyer was given to my ex-wife, my co-parent currently, and it seemed that as soon as the legal system got involved, it got ugly. In other words, we weren't happy with each other, but suddenly now the mud is beginning to be slung. There was an accusation in civil court, as you're aware. Hearsay is basically allowed, and it was stated that I was a flight risk. What's interesting, after 2 years, when I got my day in court, her attorney offered me every other weekend. So what, I can't be anywhere in the world in 48 hours? So, I mean, they didn't believe their own lies. And I called them out on that. The judge had the wisdom to give me 50-50.
Yeah. Thank you.
Thank you for your question.
Thank you very much for your testimony.
I mentioned the peer support agency. I'm just going to read.
Great, thank you. Michael Bear. Afternoon, Michael. How you doing?
Good, you?
Couldn't be better. A little cold, but we'll get through it. Senator Whitley will make me some chicken soup. I'll be doing great. Maybe not. Maybe not. Maybe Representative Karen. I heard you were a good cook. Go ahead. Say your full name and.
My name is Michael Bear. I reside in Pittsfield, New Hampshire. I'm here in support of the bill. I'll apologize ahead of time. I'm not very good at public speaking. But but I come from 4 parts of the system. I grew up in a broken home where my father wasn't around a lot due to similar situations with what's going on in the bill here. I'm a father of 5 and have been fighting the system the last 5 years for the equality with my children, of my 2 oldest ones. I also work around individuals that have been affected by the system. And also I fight for my stepdaughter whose father has not been actively in her life for almost 5 years. I hear a lot of going back and forth about the bill. You know, everybody's going towards violence, whether it's DV, drugs, or anything like that. Those are criminal. Courts already have, the judges and the courts already have the discretion to act accordingly to that. In as 50-50 or 35-50, you know, or 65-35, kids, it's not a number to them. It's not 50% father, 50% mother. The kids need 100% availability of both parents from the start. That, you know, they if you're talking about violence and all that stuff, you're already presuming that one of the parents fall into that category. Which is wrong. Like I said, the courts already have the discretion to make choices based off of that. You're not going to give a kid, you're not going to reduce a kid's ration of intake of liquids versus their solids, because that'd be considered abuse. You know, they need the 100% availability of both parents for the kids. You know, you go with shorter time, equal amount of time, you know, that'll cause a higher level of conflict. I've seen it firsthand in my case, and it continues. Not only does that aid in a higher level of conflict between the parents, it also aids in either the start of or the assistance in alienation, parental alienation, you know, for either party, male or female. I apologize. There's so much that you try to put it into the main points. But it's already written into law. Every parent, male or female, has a fundamental right that's constitutionally protected. So it should already be presumably 50-50, you know, because chances are, if you guys are concerned about domestic violence or, you know, drugs or anything that shows the unfitness of a parent, more than likely that's going to play a part in the divorce. So it's going to be brought up in the divorce proceedings. So that's going to be tended to then, and the judge can make the basis off of that. You know, in majority of the time, if there's violence, especially criminally or anything like that, the other parent's not going to be able to receive time with their child unless it's supervised to begin with. I've seen the effects of having both parents, when they are working equally together, how much more beneficial it is to the children. You know, because like my case is a high conflict case where, you know, it's right around the 35-65 that it is, and it causes a higher emotional strain on the children because they don't understand. The kids at those ages need to worry about being kids. That's all they should worry about. Of course, when they're with their mother, they're going to miss their father. When they're with their father, they're going to miss their mother. You know, but then you start getting them into when they're older and they're starting to notice things and they're starting to question, you know, well, how come we're spending this much time doing that, but not a lot over here? So now that creates distance within the children and the other parent, or vice versa. It all comes down to, if there's 2 fit parents, the kids need 100% availability of both, and then go from there. You know, because it's already written into law that even to deprive a parent or child of any time that's less that of their mother or father, it's on the courts to find that parent unfit. I mean, there's more. If you have any questions, feel free to ask.
No, Michael, you did a great job. You had no testimony and you just spoke to us. That was wonderful. Senator French.
Thank you. Thank you for coming in. I can tell you care very much for your children. If it's not too personal, what is your parenting plan now? How many days a week do you get to see?
My parenting plan now is every other weekend and Tuesday night, from Tuesday night until Wednesday. Drop off at school. Then during the summer, that's the other thing too. During the summer, it's pretty much 50-50. During the summer, I have them from Friday until Wednesday at 5:30, and then a mother has them from. In that time frame, even documented, if you look through you look at the time frame of any time the kids have disruptances in, you know, their behavior or actions or anything like that, it coincides with the reduction in time from the other parent. You know, an example, my daughters, they get real anxious when it starts coming towards the end of summer because they know they're not going to be seeing their father as much. They don't understand why. You can't sit there and tell them, well, because your mother doesn't want you to have that equal time with your father. You know, they don't understand.
So right now it's during the school year, it's every other weekend from
Correct.
Friday through Sunday night.
Yes.
And every Tuesday, Wednesday night?
Tuesday from school pickup until Wednesday at school drop off.
Okay, and then in the summertime, it goes 50-50?
Yes.
And you got that arrangement under the old laws, correct?
Yes.
And
Well, yes and no. I actually have not been in front of a judge to fight for time with my children because my ex is so high conflict. Instead of worrying about the kids, you end up exhausting everything you have through litigation, so you can't even get to the point where even you can fight for your kids, so you go through mediation. Well, mediation, they neglect to tell you that whatever said in mediation doesn't make a difference. You can lie through mediation, that paper gets ripped up and thrown out. You can't even go back to court and be like, well, this is what was supposed to happen.
yeah, I've been through it several times.
So now you get to the point where you try to get to a point where you just get to the point where you have nothing left except for the hope of it.
Yeah, gotcha. Thank you very much.
Okay, Michael, I think we're all set. Gail Drobat? Good afternoon.
How are you?
Doing well, thank you.
Thank you for allowing me to testify today. My name is Gail Drobat. I live in Hillsborough County, and I'm a mother of two amazing children. Although my immediate family is not in the family court, we're intact. Over the last several years, I've had the opportunity to meet some pretty amazing parents that have had to exhaust all means, physically, mentally, and financially, to try and protect and maintain a meaningful relationship with their children after separation or divorce. I've had the misfortune of witnessing the intentional violations of constitutional protected rights, Supreme Court protections, and state statute laws in the New Hampshire family court system. The intentional violations are unclear as oaths have been taken to uphold each of these protections. The importance of the parent-child relationship is reflected in its treatment in New Hampshire law. The State v. Robert H., holding that parents' rights are fundamental and natural, essential, and inherent rights under our state constitution. The liberty interest of the family encompasses an interest in retaining custody of one's children, and thus a state may not interfere with a parent's custodial rights absent due process protections. Parents' interest in custody of their children is a liberty interest which has received considerable constitutional protection. A parent who is deprived of custody of his or her child, even though temporarily, suffers thereby grievous loss, and such loss deserves extensive due process protections. With the above listed protections, it is unclear how New Hampshire Family Court judge is interfering with these protections with no showing of a parent being unfit while caring for their children. The New Hampshire judges are making orders that have moved children 3,000 miles away from one parent that does not promote frequent and continued contact or allow those children to have a meaningful relationship with both parents. Making a custodial mother and every other weekend parent in a 20-minute status hearing on a guardian ad litem's recommendation with no evidence of abuse or neglect is criminal. Making orders with allowing one parent to submit evidence, ignoring the facts of the case, or in some cases, not recognizing who brought the case forward and why the case was brought forward. This tells me pleadings submitted to the court are not being read. Children are going months and years with no contact with parents. Parents are having to walk away from their children due to the adversarial nature of the family court. Created by poor orders, attorneys extending litigation for billable hours, the court forcing parents to engage with biased, court-affiliated and ordered guardian ad litems, and therapists. The court exhausts every financial means of parents. I assure you the above statements and facts are true. My nephew has been abducted by the New Hampshire Family Court System for 1,545 days. After attorneys have exhausted the financial means of parents, the bias and discrimination shown to pro se litigants is criminal. The family court not reading pleadings, not holding a hearing for over 10 months in this case, a guardian ad litem that did not follow her order on appointment, and a therapist that allowed the mother in the minor child's individual therapy. The therapist was court ordered to provide billing and insurance records. She's in contempt of that order, and the court refuses to address that issue, forcing the father to pay opposing attorney fees for requesting the billing of that therapist. Opposing counsel filed perjured information with the court, contradicting perjured information under oath with the Bureau of Child Support Services. Opposing counsel violated federal law, going into the personal mailbox and putting court documents with unpaid postage. Opposing counsel presenting material misrepresentations to the court, falsely presenting evidence to the court that is fraud upon the court. When the evidence of these actions are brought to the court's attention, it falls on deaf ears, ignored, and denied. I'll give you a glimpse of my nephew. That we only received this information through school documents that have been withheld for 3 years and some behavioral referrals that have recently been provided. The mother moved the minor child out of town in school district with a week's notice via text message without a court order. From ages 9 to 14, grades 4 to 8, in the mother's sole care, the minor child has between 130 and 150 behavioral referrals. 3 suspensions, detentions, behaviors documented as defiant, disrespectful, argumentative, harassing girls, kicking shoes at teachers, blocking doorways from teachers. He's been investigated for being a bully, and his actions did rise to that. He's crushing breath mints and referencing cocaine in class. He's stealing and cheating. In 2019, the assistant principal reached out to the district social worker for this child in need of services with no response. This child is failing by a system that is supposed to be protecting him. So for all these reasons, and I hear the opposition speak to the current statute, but the starting point should be 50-50. Parents should, if there's abuse or neglect or any other reason, it should be deviated from 50-50. We're all equal. God created us equal. We have equal protections of law. So I think 50-50, if all of you would make a 50-50 amendment to this bill, because whether it's 35, 50, this court still has the discretion for abuse and neglect. And we should not penalize parents for those reasons. And it should be assumed that we're all fit, willing, and able unless otherwise proven with clear and convincing evidence of otherwise. So, thank you for your testimony. Thank you for listening to my testimony.
Thank you very much for your testimony. Are there any questions? Okay, seeing none, thank you very much. Okay, are there any other members of the public that would like to speak? Okay, hold on a second. Did you sign up to speak? Your name is? Okay, okay. Joseph Moreau, okay, and Bill Fortune. Okay, all right, and Chow Keller, you didn't do the top part, but that's okay. All right, throw me there for a few minutes. Let's see, Mr. Moreau, do you want to come forward? Oh, I'm sorry. Yeah, we'll get through everybody. Okay. You are Dana? Mr. Albrecht, come on down. Sorry about the confusion.
No worries. Thank you, Madam Chair and members of the committee. First, for the record, my name is Dana Albrecht, and I'm a resident of Nashua, New Hampshire. Please forgive I don't have written testimony, just notes.
Okay.
I'm the father of 4 wonderful children. My oldest son is at home today because he was lucky enough to be 18 and escape when our divorce started and wasn't subject to the system. Younger 3 did not fare so well. They were born in New Hampshire and have since been relocated multiple times around the country, so I don't get to see them all that much. Some of you may have heard from me via written testimony on other bills. This one I thought was important enough to come in to speak in person. And again, some of you might also have read news articles about my case, but you can take that offline for exec session. I'm here to speak today on HB 1382. I am going to argue strongly in favor of a presumption of 50-50 shared parenting concerning any realpolitik of how we get there, amendments. I'll leave that to the politicians. So that's first part's my introduction. For the second part of my argument in support, strong support of 50-50, respectfully asked you give me a brief, apparent 1-minute digression or so into some important history and case law. And then for the third and final part of my argument, we'll sort of tie the relevancy back.
Okay.
So just to, remind you all of some important historical events and how those have played out. July 23rd, 1846, Henry David Thoreau spent a night in jail. And his crime was not agreeing with stuff like the 3/5 compromise or slavery or paying taxes in support of that. And at the time he spent that in jail, but history has vindicated him. He's the winner now. June, July 1942, Nazi Germany, 6 members of the White Rose passed out leaflets speaking against Adolf Hitler, and they paid for that with their lives, college students, by guillotine. And at the time, they were the losers, but history has vindicated them as the winners. Moving on, back to American history, 1954, you have Brown versus the Board of Education. Again, another landmark equal protection case. People of African descent, people of European descent should have equal protection under the law. How come it took us till 1954 to get there? Henry David Thoreau was there back in 1846. Moving on, December 1st, 1955, someone named Rosa Parks decided that, she didn't agree where she was supposed to sit in the bus. Again, it's equal protection under the law. April 16th, 1963, Martin Luther King spent a night in jail because he believed in equal protection under the law. And on that night, he was a loser. but history's vindicated him. Who's the winner now? Moving on. 1963, Gideon B. Wainwright. We finally decided that people who were too poor to afford a lawyer should actually get one. He got some equal protection. He was in jail too. Kind of see the theme here, people in jail. 1966, Miranda versus Arizona. We finally get this concept that people should have equal protection in court, at least in criminal cases. We're not there yet for civil cases. They deserve a lawyer. Moving on, 2000, and that's a certainly important one for this bill, you have Troxel v. Granville, which establishes, pretty clearly under the 14th Amendment that a presumption that parents are fit and a presumption that they have equal protection. And, it's not based on a lot of prior case law supporting that. Moving on, 2004, the one case probably a lot of you might not hear one. It's not as important as the others. It's near and dear to my heart, though. It's Albrecht v. Metropolitan Pier and Exposition Authority, from 2004. First Amendment rights, McCormick Place, Chicago. Again, upholding fundamental constitutional liberties. There's a 172-case settlement for that. I'm going to give my wonderful ex-wife credit for most of the work, but that's the one thing we do agree on. That was a good thing. 2011, we have our own state Supreme Court, Kurowski v. Kurowski, and that pretty much, sort of articulates at a state level them upholding, United States Supreme Court, Troxel v. Granville. You move on, 2014, something like McCullen v. Coakley really establishes equal protection for people who don't agree with each other to be in the same place at the same time in public, as long as it's peaceful. That one's also kind of near and dear to my heart because Eleanor McCullen, the plaintiff of that, someone who's kind of been a mentor to me. I've had the opportunity of spending a lot of personal time with her. You go a year later, something like Oberfell, I can't pronounce that, v. Hodges. Finally, we get to this point where people who want to get married, at least the state's going to step out of who that's supposed to be. Leave it to the religious denominations. We even have pending stuff now before the U.S. Supreme Court, like New York State Rifle and Pistol Association. That's, New Hampshire has led the country in having gun rights, but there's a few states that lag there. And, maybe their people in those states are finally going to get some equal protection on that. Hopefully it's still pending. Another pending one, Dobbs v. Jackson, Women Health. We're finally looking for equal protection from 16 weeks onward for children. And so from my point of view, so much of this is about people, all people, regardless of race, creed, color, religion, age, receiving equal protection under the law. And that's sort of the second part. Again, religion, race, whether you're too poor to afford a lawyer, whether you've been born or not, whether you can protect yourself, all equal protection. And so I think the questions here before this committee have almost less to do ultimately with the details of this bill. Again, I'll leave that to the politicians and the lawyers. But whether we're all going to be viewed as being the losers of history or the winners of history. Because hindsight's 20/20. And when you look at a lot of these other things I talked about, the people at the time who were ahead of the curve were viewed as the losers. They paid with their lives, they spent time in jail, and history has vindicated them. And now they're the winners. And the people who stood up against them are now mocked. And so the question is New Hampshire going to lead or is it going to follow? I heard in prior testimony we've got 6 states who already have shared parenting. They're the leaders. They're ahead of the curve. And I heard we've got 9 states, including us, who's got an F. Kind of sounds like we're the followers and behind the curve. And what typically happens eventually with the followers who are behind the curve, when it's something this important, you know, some of the key societal issues, parenting, gun rights, abortion, you name it, eventually winds up getting decided by the U.S. Supreme Court. And a lot of state laws get overturned. So why not write them right from the beginning? Why not get this right? Why not be leaders instead of followers? And so I kind of ask, you know, like a 35, 65%. I mean, that sounds like a 3/5 compromise to me. You know, sometimes people need to make compromises to get stuff passed. That's pretty common in history. But, you know, that still says there's a winner in family court and there's a loser. And that's not what we want. We want children to be winners. We want mothers to be winners. And we want fathers to be winners. And we want families to be winners. And just to sort of close, to rebut a couple things I heard earlier here, I think a whole lot of the domestic violence stuff and, you know, the idea that there are some unfit parents out there is a red herring. There's nothing in the law, nothing in any of the case law, nothing in any of the history that I cited that would ever imply that a single individual who's guilty of wrongdoing, you know, shouldn't be dealt with appropriately by society. But in this country, we should or ought to have a presumption of equality and equal rights under the law. And that's in the best interest of our children, in the best interests of our families, and shows us to be leaders. And again, presumption. There are convincing evidence, something to the contrary, the judiciary should have discretion to handle that, and I think they still would. Thank you for your time, and I'd be happy to take any questions.
Hey, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Mr. Albrecht, just, did you hand this in?
No.
Okay.
I certainly support that, but that's not my work.
Okay, I just wanted, if it was, I just wanted to indicate that it came from you.
Okay.
So, thank you very much for your
Thank you.
testimony this afternoon.
This afternoon.
The chair will call Joseph Moreau.
Afternoon, Madam Chair, members of the committee. My name is Joseph Moreau. I am a retired U.S. Army sergeant. I live in Milton, New Hampshire, where me and my wife run a 12-acre horse farm, and we practice sustainable living. A very good atmosphere for 3 young children, who I'm a proud father of. My oldest, Abigail, was born in 2009 and saved my life. I was flown out of Afghanistan in July 2009. I was working with the Joint Special Operations Command Center, entry control points.
Mr. Moreau, can I interrupt you for a second?
Sure.
Ladies, if you're going to talk, could you take your conversation out because we can hear? Okay, that's okay. Thank you very much. We appreciate it. Sir, please, I'm sorry. I didn't mean to interrupt you, but we could hear the chatter and
Yes.
I want to be able to hear what you're saying. So
Thank you.
Please continue.
I luckily made it home 2 days before Abigail was born. It was the most beautiful thing I've ever seen in my entire life, and it changed my perspective on living. I've had 2 more since then, and they're amazing kids. For the last 3 years, I've been alienated from my children. I'm happy to report that I've started seeing them since February. What's bothered me is a lot of mental health red flags in my children. things that they've been told about me that are untrue, yet I've been ordered to not talk about the cessation of time. I comply with that order. The 50-50 parenting, I believe, is important. I would ask that it is supported, because without 50-50 parenting, I'm not able to access mental health support for my children. I cannot do anything about getting them to see a counselor. And what I've been told by the court is that it's going to be up to my co-parent. I've asked to go to therapy with my children. She said this would be harmful to the children. I don't understand how therapy would be harmful in this situation where we could all express ourselves in a progressive manner. I understand that with domestic abuse issues, that it is very hard for an individual to leave an abusive relationship. It's hard for me to admit that I was abused in a relationship, emotionally, financially. I don't want to say physically, but almost. I don't like being lumped together in a category of people that have committed these acts. I haven't committed them myself, but I'm viewed as a monster to my children. This has been more than painstaking. It's been a fight that I didn't want to fight. I've never wanted to fight. Since I've left the military, my goal is to farm, to be my garden. That's it. It brings me peace of mind. I get to see my children every weekend now for about 8 hours. They come to my house and they're asking me recently, why are we not allowed to spend overnights? Why can't we stay with you, Dad? We have school vacation this week. Why can't we stay with you? Can you talk to Mom? No, I can't. It's like talking to a brick wall. I used to have 50-50 with my children until 2019. She was awarded sole physical and legal custody through the state of Massachusetts. She left Massachusetts during this time and moved to New Hampshire without reporting it to the court or myself. I have a request for admission here and a letter from my doctor from the Department of Veterans Affairs explaining the situation and what I've gone through. I've been told by the court that I need an attorney every time I go in, yet I can't afford one. 3 years and $15,000, and I feel very lucky saying that amount. I've seen some people that have spent what looks like a home mortgage, on battling these cases. I can't afford it, so I have to go in and represent myself every single time. Do I feel not picked on, but the best word for it is not prepared. I am made to feel not prepared every single time I go in. 461-A, the rights and responsibilities of parents. It's on both the parents to provide equal support, equal care, and to be part of their children's lives. Yet I'm not allowed to be because of one person. I've addressed this with 2 states, 3 courts, 6 judges, and 4 attorneys. I'm still fighting. I requested mediation. She objected to mediation. I'm done fighting. I don't want to fight anymore. I've been asked to not litigate this and focus on the therapy, yet I'm not allowed to access therapy for my children. I've heard a lot of great points you made today during testimony from both sides, and it has given me, room to reflect on it and really take back. I have to go back to the drawing board a little bit and, rewrite my argument. I don't want to take up too much of your time. At this point, I believe it should be supported from the beginning to have 50-50 support all the way through. The courts do have the ability to take away or give. I just don't believe I should be in the same category as people who have done things that would be deemed necessary to, take custody away from them, for their children. I don't really have much more to say, as I think a lot has been stated here that I wanted to talk about, but everybody else has done a great job of making some good points. So at this point, I'd like to open to any questions if that be.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call William Fortune. Good afternoon, Mr. Fortune.
I'm Bill Fortune. In the early 1970s, I'm New Hampshire founder of Fathers United for Equal Justice. Been working on this issue for many years. The number 50 years in the first line of the first paragraph should be 70 years. We've been working on this problem for 70 years, and it's just gotten worse. So the fact that this type of legislation was not introduced more than 50 years ago shows just how much society has deteriorated and how sick society is. Note that we have known since the 1950s that boys from father-absent and female-dominated dwellings have a much higher rate of juvenile delinquency. It's only recently that such studies show that girls that don't have a positive relationship with their father have more serious and more frequent emotional problems. All the info is available if you Google it. The evidence is mounting every day. More violence, more suicide, more drug use, more homelessness, more depression, more hopelessness, more anger, more chaos, resulting in more mass hysteria that threatens the nation. Now, I'll jump down to the bottom of the page, and I don't want to make anybody's head explode with some of my comments. About fostering good mental health so people can be nurturing parents. I suggest we implement programs replacing sex education if necessary to show children, and of course adults, how to use their relationships to resolve their emotional problems. In other words, replace what they miss or replace the dysfunctional parenting that they receive, or parenting they didn't receive. Just reversing the trend of having the school system raise children from birth, being daycare centers, and mental health infirmaries controlled by the police. Showing people how to resolve their issues will lead to emotionally healthy two-parent families, which leads to less money for education, lower property taxes, fewer police, and a more stable community. We also need to remove family issues from the legal system and away from the divorce lawyers, and require that those issues involving children be under the review of a forensic psychologist, not psychiatrist. Also restore the mental health profession. We need to restore the mental health profession because I can't find any psychologists that are willing to testify in court. They get battered by the lawyers. This reduces, getting the psychiatric profession back involved reduces domestic violence and the need for gun laws. I want to note that the guardian ad litem established to protect children, not for lawyers and others to make money. I want to note that, I'm sorry, I will charge them with endangering the health and welfare of children. Boys need to be taught what is needed of them to be fathers, especially what their daughters need from them. I'm looking for young people who have been emotionally damaged by the divorce industry so we can sue the state divorce lawyers and the social workers. and UNH for not teaching people how to resolve their emotional issues. Let's go back to top of the page here. Girls without a positive relationship with their father generally have low self-esteem, which can't be taught by the government. They have they have seen no examples of how people relate in a healthy relationship and have no role models to help them choose a mate, which is reducing their chances and their partner's chances of achieving intimacy. I'm going to skip the next paragraph. I'll just skip parts of the next paragraph. Mike Gianolis and the legislature spent over 10 years getting the guardian ad litem law passed. Mike didn't focus much on children's rights and refused to address any psychological issues. So here we are today, back at square one, and in some degree worse off because the divorce lawyers and the feminist social workers and other parasites, along with the universities like UNH, the police, the courts, and the politicians, help destroy the emotionally healthy two-parent family. The guardian ad litem program was intended to give children a voice. It has turned into a money-making proposition for lawyers and other parasites. Lawyers always take advantage of people's problems to make money. Many young women suffer from broken home syndrome, went to universities to study social work. Most were looking for answers. Instead of teaching how to resolve their issues and help people resolve their issues, UNH, for example, taught women's studies, which focused on domestic violence and how females are victims. Then politicians got into the fight and passed laws to control people, like we have in the schools today. We're going to try and control people who have emotional issues instead of solving the problem in the first place. In the 1970s, many women at the legislative hearings demanded that the government replace the father, give them more daycare, more child support, alimony, no-fault divorce, and other social benefits, and they would raise better children. When I suggested when children needed two parents, they told me to sit down and be quiet. All this exasperates the problem, bring us days where those dysfunctional children suffering from broken home syndrome can do like the golden rule. Do unto others as was done to me. Like they say, you don't care about me, so why should I care about you? So what if I cut your throat? Who cares? Nobody cares. After this law is passed, and I expect it will be, we need to work on children's rights. The right to be raised by two emotionally healthy parents instead of being housed in government-run infirmaries controlled by the police, which is our school system.
Mr. Fortune, I'm going to ask you to stop reading because we have your testimony here. Can you just paraphrase the rest of your testimony?
I'm all done.
Are you sure?
Well, I've read everything on this.
Okay. Yeah, I know, I was following too, so we have other speakers, and I just want to
Yeah, I
make sure
know.
that they have a chance.
Some people took a lot more pages than I did.
Thank you very much for your testimony, Mr. Fortune. The chair will call Chow Kelly.
Thank you, Madam Chair and the committee for allowing me to speak.
Please, Miss, could you pull it closer so we can hear?
Can you hear me now?
Thank you. Yes, we can.
Thank you. Yeah, my name is Chow Kelly. I'm from Hooksett, New Hampshire, and I'm here to support HB 1382. A little background, I used to go and translate a lot for a lot of family in different kind of course, and all over New Hampshire and other state too. So I'm very familiar with this process. And what I've seen is the 50-50 should be guaranteed in the law because it takes two to have a baby, so it takes two to raise, no matter where the parents choose to live. So I heard earlier testimony that, what about the parents living far away? So why don't they make that decision thinking about the child where they should locate so they can be near the parent, the kid, if they want to get involved with the kid. And also I have women like from Vietnam that they have very limited English and they're married to an American, for example, right? And when they get divorced, cannot drive. So for her, she's so much afraid of losing her child because she looked like a disadvantaged parent to have a parenting right. So if we're talking about what is the best interest for the child, who decide that? You know? So we're talking like abusing parents in the child's life. But from like this woman's point of view, I cannot speak much English, I cannot drive. But if I get divorced, I'll lose my child. If I don't agree to whatever in the mediation process that the husband wants, and the husband want to move out of state and she cannot get the kid. So we had to have that 50-50 in the law to make sure that all parents, doesn't matter what walk of life and ability they have, they should have take part in their child's life, 50-50. And whatever the decision before you have a kid, it's easy. But if you have a kid, you have to consider that kid in your decision to make. So the law need to take that part in there. Because my nephew go to school, and all of his classmates, the parents divorced. He came home and he told my brother that I'm one of the few that you can count a hand, that the parents still stay together. And he's so much afraid that his parents someday get divorces like his friends, who is a juvenile, get arrested so many times. And my family, my father, was imprisoned as a prisoner of war after the Vietnam War by the communists for 7 years. I grew up not knowing my father. And my mom alone, a single mom at that time, raising 3 kids. She had to whack us sometimes to keep us in line because we kids, we very wise, we don't listen. You know, 1 minute don't do that, the next minute we forgot all about that. We need to be smacked a little here and there to retain our memory. So that is not abuse, because I got into many phone calls that parents told me in the community they're so afraid to smack the kids and teach the kid the right thing to do because the kid can just pick up the phone call and call the police and they lose their children. And my mom said to my little sister when we first came to this country, you know, you go ahead and call the police. I go to the prison, but you're gonna come home from prom by 9:30. Not past that. And then when she passed that time, she came home, my mom had a stick waiting for her in the parking lot and whacking her from there into the house. And the neighbor called the cop on us. The police showed up. Is there no problem? We have no problem. The cop went home. So if we are not allowed to be parents, to teach the kids, we have a bunch of wild animals that looking like human on the street. Is very dangerous for our humanity, our society, and the security of our country. Is our future or the future, the leaders of our country. So this bill is important. That's why we take the time out to be here today. So please support this bill. It doesn't matter what political party is. It's humanity at stake here. So kids need both parents in their life, no matter who they are. And please redefine that domestic abuse thing, because that's not domestic if you want to raise your kid right. My mom can say all day long, we don't listen. But if my dad raised his voice once, we all listen. And my brother, 20 years old, he still lay on the ground. My dad whacked him with a stick. And we still a kid in my parents' eyes. So, so please support that bill. I appreciate it. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Okay, are there any other members of the public that would like to speak to House Bill 1382? Okay, seeing none, we'll close the public hearing. Thank you. Let me know when you're ready, Jenny. Going to go ahead and open the public hearing on House Bill 1416 and recognize Representative Keller, who is going to be introducing the bill and speaking to the bill for Representative Bolden, who was not able to be here this afternoon. Good afternoon again, Representative.
Thank you, Madam Chair and members of the committee. For the record, my name is Joshua Keller from Rockingham 33, towns of Fremont, Danville, and Brentwood. I am introducing HB 1416, which is relative to consent of mental health treatment in parenting cases with shared decision-making responsibility. And this bill was brought to the Children and Family Law Committee with the idea that when you're sharing responsibility or decision-making responsibility, and the child needs some mental health services, and that you should be able to provide those without having to, unnecessarily do burden, and you should be able to do that without necessarily getting the approval of the other parent, but because there are very important to get done, sometimes even right away. And that, however, that this language requires that you notify the other parent before that happens, because sometimes the other parent is financially responsible. So the committee did not feel that the other parent should find out that they're receiving services by getting a bill in the mail. They should actually know when those services are happening beforehand. I have talked with some mental health people about just having one parent approve of the treatment, and they said that it is very dangerous for them to do that, because if the other parent doesn't really like what the services provided, they may complain to their licensing board that they did something inappropriate. And so I think this would be only used in very rare circumstances, because the providers are very cautious of wanting to have both parents approve of that, so that they have some buy-in to what the provider is going to be doing, so that they are not endangering their license. However, if the treatment is necessary and they have a provider that is willing to do that, especially in times of emergencies, if someone had a drug abuse addiction and they needed to go into treatment right away, that should be, they should just be able to let the other parent know, and on the way to driving to that service, and not hinder that process up. So I'm happy to answer any questions.
Thank you very much for your testimony. Are there
Absolutely.
any questions? Senator Khan.
Yes, thank you, Madam Chair. I wanted to if a parent is notified,
Right.
is there any, what is the expectation beyond that? What is the expectation beyond the notification? Did that, was that part of the hearing? I mean, I understand a notice, but is it something that there needs to be mutual consent of the appropriate, or if there's shared responsibility, you know, it says parents have joint decision-making responsibility. I just, yeah, as I read this and parent is notified.
Right.
Then what?
Thank you for the question. So this would be only for cases where they had shared decision-making responsibility and one of the parents wanted to get some mental health treatment for their child. And so there is no, in this law, there is no additional thing that those parents would have to do except notify the other parent that, hey, we're going to go seek this mental health treatment because we feel that is necessary. And so the other parent wouldn't have to approve. They could say however, if they had notification and before the treatment happened, they could obviously go to the court and have an injunction or something and say that this should not be allowed because it's not in the best interest of the child or something like that. And so there is that opportunity for them to challenge this, but this, I guess it was the sense of the committee that if you're going to mental health treatment, then it's like the provider is not going to do something that would be harmful to the kids. And so we should err on them being able to seek that treatment. And so, yes, thank you.
Thank you.
Are there any further questions? Representative Keller, who determines that the child needs mental health treatment? Is it one parent who thinks they might need some counseling, or is it a school, or is it the doctor?
Thank you for the question. So in this law, it would be the parents that would be seeking so each parent has joint decision-making responsibility. And so this would allow them, either parent, to be able to consent to the counseling service independent of the other parent. So you wouldn't this doesn't really touch on like a school saying, hey, this is just about parents having shared parenting responsibility and one parent saying, okay, we need this drug counseling, and the other parent either may not have time to have been aware of the issue, and that's why the notification comes in, so that they could know that, hey, this is an issue and we need to go to seek this mental health help. But no parent would be able to forbid, I guess, the other parent from getting the mental health treatment of the child, because under this law, each parent would be able to consent to those counseling services. So they would have to go to court essentially to override that other parent's power to consent under this law.
Okay, what if one parent says, I want this child to go for mental health counseling, and the other one says, no, I don't want them to go? Are you saying that they're going to have to go to court?
Under this law, the person that says yes, that they need to go to mental health counseling, that person would be the default, essentially, winner in that argument, unless they went to court and overrode that default position. Because it says in the law right here, it says if the parents have joint decision-making responsibility, either parent may consent to the counseling services of the mental health of the child. And so they only need one person's. However, I did mention that some service providers have expressed concern that they would want both parents' consent.
Right.
So
Okay, thank you very much.
Absolutely.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you.
The chair will call Chow Kelly. Could you turn on your microphone, please?
Sorry. Thank you, Madam Chair and the committee. My name is Chow Kelly from Hooksett, New Hampshire. And yes, I'm here to support HB 1416. It only makes sense that, you know, in the past few years with this pandemics that's going on, a lot of kids have mental issues, even adults. So if one of the parents don't recognize the kids have the signals that they need help, then the other one, if they find like, yeah, kid need to see doctor for their mental health, then they just need to notify the other one to make sure the kid is healthy. Because I have friends and clients that she's mental, but she doesn't even recognize that she's mental. So if a mother is like that and the family deny that too, that, you know, they don't want to recognize that the mother is a mental person. So if the father see the kids need help and the mother don't even recognize her own problem, then, or vice versa, I'm not saying the gender here, you know, then the kid need to see doctor and they just need to notify the other person. That's very common sense. You know, I mean, I didn't know that in America there's so many laws that is a common sense thing that people should just do that. Now we have to make law to decide little things like this. But yeah, I'm here to support this bill to help the kids from the little age so that they can be healthy. I don't know, maybe I should see doctor too, because I went to see to my bank yesterday and I saw this gentleman in the bank. He's dressed as a man, but he has all these funky nails like me, like a woman. You know, it's like, I'm very confused myself. You know, I mean, kids that growing up nowadays, in school they taught like gender and sex is different. And I saw this video, I'm like, after I watched the video that teaching kids, I'm confused too. I need to see a psychologist too myself. So I think a lot of kids need that service in the future. And one of the parents, if they sweep enough upstairs, they should get help first. Thank you.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you.
Yeah.
Are there any other members of the public that would like to speak to House Bill 1416? Representative Yacola, can you come up forward, please? Or Keller? I'm sorry.
It's quite all right.
Senator French has a question.
You support House Bill 1560. And you support House Bill 1382. But in 1416, it calls for shared parenting, correct?
Yes.
1382. Yeah. So it defines shared parenting with equal role in decision making, yet in this bill it says all except for mental health issues. How do you justify that?
Thank you for the question. I'm not sure I need to justify it. I'm just saying that there is shared decision-making responsibility should be the default. However, in mental health situations, there may be we may want to err on the side of the child getting services. Remember we talked about if parents can't agree, that nothing happens until they have to go to court. Where in this would allow, if they weren't able to agree, we would err on the side of those kids getting services. And so I think it was in the committee and myself believe that in those cases when they're not able to agree, we should err on the side of those kids getting the services that they need.
How about other medical conditions?
That bill didn't come before us, so I didn't consider it.
Okay.
Thank you.
Thank you. Thanks for coming back.
Thank you, Representative. Again, are there any other members of the public who would like to speak to House Bill 1416? Okay, seeing none, we'll close the public hearing. This is
Yeah. The lifesaver I had.
1303 and 1305. You know when you're all set? We're going to go ahead and open the public hearing on House Bill 1118 and call the prime sponsor, Representative Griffin.
Thank you, Madam Chair. Thank you, members of the committee, and my apologies again to the committee for being noisy over there in the corner previously. It's an important thing that you were hearing, and I apologize for interrupting it. In regards to this bill before you, I apologize. My name is Barbara Griffin, and I'm a representative from Goffstown. The bill that is before you proposes to add a fact to be considered by the court in a determination of parenting responsibilities when a parent has died or when a guardian who has held the position for 2 years has died. And the fact that I'm asking you to consider in this bill is that the court shall consider the wishes of the guardian in estate planning when there has been a placement for 2 years. Children may or may not be subject to parenting orders, and in fact, they may only have contact with one parent, not due to court orders, but due to practice. And they can also be with guardians, family members, in arrangements that occur for years. But over the last 2 years with COVID, I can tell you that as a guardian ad litem, I have seen a number of cases being brought forward as to terminations because of concern about what would happen to a child who has been in someone's custody legally if they were to die because there is a surviving parent who at that time is not capable of taking care of them. And the concern is they would automatically go to that parent. This concern is being raised both by the custodial person acting in the parent role, and it's also being raised by children. I've had children say to me directly they were worried about what was going to happen if their guardian died because of COVID. And so I've simply asked for this statute, for this particular piece of legislation to be drafted to provide that the court shall consider the interests. And the 2 years was long enough so that if a parent had been trying to be a part of a child's life, possibly through an abuse and neglect proceeding, there was certainly long enough time for there to be evidence that that was going to be successful. I have been involved in abuse and neglect cases as a guardian that have gone on for 2 years, trying to facilitate reunification. And in a case of a guardianship, by the time you get to 2 years, that's really created a new stability for a child in regards to the parenting arrangement that's occurred as compared to sometimes guardianships that really are temporary and voluntary. So I didn't think it should be a blanket consideration, but I did think there were cases where it was appropriate that it would be considered. I've used the term shall to not only put the court on notice that it should be considered, but also to put parties on notice that it should be considered, that if they do go through the steps to do estate planning or take other steps for planning for children who might be in their legal care, that in fact the court would pay attention to it if they were to die. These are pretty limited circumstances, but they were a circumstance of great concern to the children and families I met during COVID over the past 2 years. And I would be happy to take any questions.
Hey, thank you very much for your testimony. Are there any questions for Representative Griffin? Okay, seeing none, thank you very much.
Thank you.
The chair will call Representative Keller.
Thank you, Madam Chair and members of the committee. For the record, my name is Joshua Keller from Rockingham 33, the towns of Fremont, Danville, and Brentwood. In the committee, we heard this bill, and I just wanted to be here to answer any questions and say that one thing is that to note about this is that it's not prescriptive that they follow what is in the what are they calling it? The estate planning documents. It's not that it's just required that they consider those things. So the court still has the flexibility to say that that's not appropriate. So, but I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public who would like to speak to House Bill 1118? Seeing none, we'll close the public hearing.
Okay, start reading.
Thank you. Thank you, sir. Chair?
Oh, no, thank you.
No, forget it, I'm last, no, forget it.
It's moderately healthy, he's not gonna eat it.
Okay. Thank you. Thanks, Jay, for sharing.
What?
I didn't share my cookies yet, he shared his.
Yeah, I know.
Yeah. I was trying to be all inclusive.
Yes.
You're all set, Jenny? Okay. We're gonna go ahead and open the public hearing on House Bill 1303. Seeing that Representative DeSimone is not here, I imagine Representative Yokella is gonna present the bill to us today.
Yokella Day. This.
Thank you, Madam Chair and members of the committee. For the record, my name is Joshua Keller, Rockingham 33, the towns of Fremont, Brentwood, and Danville. I am here to introduce HB 1303, which just really changes the language as far as 458:7 Roman 7. The current statute says when either party is a habitual drunkard and has been such for 2 years together. And so, so this just changes that to when either party habitually abuses alcohol or drugs and has been doing so for 2 years or more together. And it's just more of a cleanup bill. I mean, it does add the use of drugs to this, which currently it only talks to alcohol as far as drunkard meaning. And so I hope the committee will support it. I'm happy to answer any questions.
Thank you very much for your testimony. Are there questions? I'm just looking at, because I saw this was on consent calendar from the House, and it just says it simply updates verbiage from drunkard to alcohol abuse, but it does add drug abuse to causes for an absolute divorce.
Right.
So just want to make that clear. So, okay, thank you very much. Are there any further questions? Seeing none, thank you. Okay, are there any other members of the public that would like to speak to House Bill 1303? Okay, seeing none, we'll close the public hearing. Okay. Oh, we've got one more to go. Yeah.
Yeah. To wind down.
Oh. We're going to go ahead and open the hearing on the final judiciary bill of this session, which is House Bill 1305, and we will recognize Representative Keller, who's going to introduce the bill for Representative DeSimone. Welcome back. We should have just a chair just for you today.
Thank you. Thank you, Madam Chair and members of the committee. For the record, my name is Joshua Keller from Rockingham 33, Brentwood, Danville, and Fremont. Yeah. So this is HB 1305, which deals with temporary alimony. Currently, temporary alimony is not counted towards the full length, towards the time you're able to pay alimony, and they don't are not required to use the formula for normal alimony calculations. And so this would change the presumption that they would actually be using that formula unless there was immediate irreparable economic harm would result, and that the amount that they're paying actually goes towards the total amount of time that they can be paying alimony. And that's it. I'm happy to answer any questions.
Okay, thank you very much. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to House Bill 1305? Okay, seeing none, we're going to close the public hearing. The committee is going to be in recess until 6 o'clock.
Oh.
It is, this is what we have, 14 bills to exact. I want to make sure that everybody has time to read the testimony received today. There will be some amendments, and we have 6 bills that we need to do. I think we have 14 altogether, correct?
Yes.
So I want to make sure everyone has an opportunity to read all their testimony and come back here. Okay. The committee will come out of recess. Is there a motion to go into executive session?
So moved.
Moved by
Second.
Senator Whitley, seconded by Senator French. Okay, what I'd like to do is take up the ones that we heard today.
I'm out of order then.
Yeah, the first one we heard was House Bill 1280. We have a number of amendments, and we have Amendment 1814S, 1813S, and 1820S. I asked Mr. Lehman to some amendments, first 13 and 14. So Mr. Lehman, would you like to walk us through those?
Sure, they're pretty self-explanatory. They're two variations on the same thing. If you remember, I asked Representative Roy a question about his intent for the bill, the way it was drafted. It would have only applied the exclusion for vaccination to circumstances in which there was a mandated vaccine by the state or federal government, which didn't sound like what he was after. So the amendments strike out the part that indicates that the vaccine has to be mandated. And then in version 1814 says that a parent's decision may not be used as evidence in any proceeding for termination of parental rights. And the other option is 1813, which says that a parent's decision shall not be used as the sole basis for terminating parental rights. And those are two different ideas wrapped around the same thought.
If I may?
Yep. And then Senator Khan.
Thank you, Madam Chair. So taking up 1814 first, this is not something that I could support because I don't want to, when we're talking about the safety of children, I don't want to exclude evidence. So, I don't think we would want to exclude any evidence related, to the health and wellness of the child. It could be part of a larger picture of access to health and wellness, but I do think that 1813 is something that we can reach consensus on. So from my perspective, I would be more inclined to support 1813 over 18. I would support 1813 over 1814.
Okay, Senator Khan?
I was going to offer a motion of ought to pass on Amendment 1813.
Okay.
Could I speak?
Yes, please, Senator French.
I prefer 1814, and I don't think it should be used at all because I don't believe it should be taken into consideration at all because I don't believe it's a sign of bad parenting.
Okay.
And I think I would like to move Amendment 1814.
So Senator Khan has made a motion. If
And
there's
I
not
second it.
Senator Whitley
Okay, now
seconded,
she
so-
seconded it. Okay.
Well, may I also add then in discussion? I think I have the votes.
Oh, okay. All right. We're discussing 1813. We just wanted to have some different options here. I think that, in my opinion, 1814, I think is stronger because it says shall not be used as evidence in any proceeding to terminate parental rights. And the other one says shall not be used as the sole basis for terminating parental rights. I think 1814 is just stronger. Senator Khan?
So I think we're coming at this in different angles. Why I think 1813 is stronger is that I don't view that as a COVID-related amendment. I view it as any kind of vaccination, DPT, and so it's for that reason that I see it as a matter of difference in the health care of the child and something that ought to be a part of evidence in a hearing.
Okay, I'm just, this, so what I hear you saying is that in 1813S, it allows for the fact that a child has not been vaccinated to be used as evidence, but not the sole basis.
Correct.
For terminating parental rights.
Absolutely. I would oppose if it said sole basis,
Okay.
which is, I think,
Right.
where we,
Because it could be, just to build on what Senator Khan's saying, when we're talking about whether a parent, is able to keep a child safe and raise that child, of course, we don't want just the vaccination to be the sole determination there, but it could be, setting COVID aside, no one wants their kid to get mumps or measles, like all these preventable things. So it could be, we don't want to exclude evidence about the overall picture about whether this child is getting proper medical care. So I think it's important, we can't, I just don't see a reason why we would want to exclude that from the conversation. I certainly don't think it should be the basis for terminating parental rights. So I think that's why I think 1813 is the better.
So I very much understand where you're coming from on that, and I do appreciate that. My problem is, I don't think it should be taken into consideration at all. I don't think it's a matter that would affect the balance on the scales of justice on whether child or that parent should be deprived of their rights to the child. And that's why I'd like to exclude all vaccinations at that point.
So the other thing too is, what are we going to exclude next? I think when we're talking about these situations, they're very specific to the parent and specific to the child. So I think it is a slippery slope. Putting aside vaccines, I think it's a very slippery slope for us to be putting in to statute what courts can and cannot consider. Because we're excluding evidence, meaning that it can't be submitted and the court can't even, use it as a consideration. So I think it's a slippery slope when we start telling the court what to do.
Well, we do it all the time.
Well, especially.
I mean, we wrote all the laws that the courts adhere to, so.
We're taking away discretion of the court, so I just wanted to make that clear.
Okay, so we have amendment 1813 has been moved and seconded. Is there any further discussion on amendment 1813S? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Opposed?
No, nay.
Okay, so it lost 2-3. Okay, the next amendment is 1814S.
Move on to pass, second.
Okay, so we have it not passed and seconded by Senator Gannon. Any discussion? I know, I think we've kind of talked about it when we were talking about 1813. So.
we did. The only thing that we didn't talk about is what happens if 1814 passes and there is a subsequent amendment. Okay.
No, well, everyone votes here the way that they want. So, again, I just think that 1814 makes a stronger case about not using a vaccine status as evidence, especially when you're talking about terminating a parent's rights. That is extremely, extremely serious. And I would think that if you're going to terminate the parental rights, that it's going to be based on something very strong. So we have amendment 1814S. Is there any further discussion? Okay. Seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
No.
No.
Okay, so it passes 3-2. All right, next we have amendment number 1820S. I will move on to pass.
Second.
Seconded by Senator
French.
As you know, now we are entering into, some people call it the silly season, where people start attaching bills to other bills. This one is familiar to all of us. It deals with the interstate compact for the placement of children. This was originally attached to a bill that was authored by our good friend, Senator Khan. And it passed the Senate. It went over to the House, and it went over to House ED&A, where last night they decided they did not want to pass it, felt it didn't belong in their committee. It should have gone to children and family law. So what I've done is I've taken this amendment that I had attached to Senator Khan's bill. There is another amendment that we had also passed that is in this as well, and I'm not sure exactly where they placed it, but it deals with the commission for the placement of children. We have had one in place since the 1960s, and it has not been updated since. There is a national movement to update this particular compact, and as with any compact, you need to get a certain number of states before people actually start working on it. I believe that there are over 20 states that have now signed on, and I believe the threshold is either 31 or 35. There are states now that are considering adopting this compact, and I think it's important that we pass this so New Hampshire can have a seat at the table. So if we attached it, this bill will, because we've changed it, it will probably go to Children and Family Law for a committee conference, and hopefully we can resolve these issues. So I move ought to pass on amendment number 1820S. Is there a second?
Second.
Okay, Senator.
Senator Khan.
Oh, you did?
We already did this.
Oh, okay. See now. Thank you. So we have an ought to pass and second. Is there any further discussion on amendment 1820 Senator
Yes.
Khan?
So as this was, as the House was considering Senate Bill 397, which this was a part of, I had thought that their hearing yesterday was going to consider an amendment that the House wanted to put on to Senate Bill 397. In fact, I know I have that.
Yes, it is an amendment that I brought in that took the part about reaching out to neighboring states and coming up with some sort of an understanding. And I know I have it, it's in the other bill, but they did adopt that. They put that into statute. And yes, they did. So this is the compact itself, the totality of the compact. And it does include that language as well, because it is one of the charges of the compact that they consider that. But they did adopt that. And it's and again, the reason this came forward was because of the case of Harmony Montgomery. And the fact that a home study wasn't done, there was no communication between the state of Massachusetts and New Hampshire about this little girl. So we want to make sure that there is going to be communication, especially when a child is going to be placed here from another jurisdiction. So that way we know about it and we can follow.
I see, I have the amendment here.
Mm-hmm.
And it would have gone into section, section C, section 3, 4, the new section on interstate contact on the placement of children.
Mm-hmm.
Do you believe that those two items have been incorporated into this?
Yes. Mm-hmm.
Which is good foresight, because if the House is going to render its opinion yet again on this, it'd be great that we've incorporated a couple of things that they thought were important.
Mm-hmm. Yeah. Mm-hmm. So are you good?
I'll be good on this no matter what. But,
Okay.
But I think, hey, my point is, I'm trying to not do any more amending on this down the road, on the floor. We can do a further check to make sure that this is, in fact, incorporated.
Yes. That's, that I was told that by the committee chair this morning because I had a conversation with her. the House EDA.
And then we've carried it forward into Amendment 1820.
Yep.
Alrighty.
Okay, so we have an ought to pass motion on amendment number 1820S. Is there any further discussion on the amendment? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
I move ought to pass as amended.
Okay, we have a motion of ought to pass as amended on House Bill 1280. Is there a second?
Sure.
Seconded by Senator Gannon. Is there any further discussion on the bill as amended?
So unfortunately, I certainly support that, the amendment that we just adopted, but I can't support overall the bill because I think, the vaccine piece is a little bit reactive to what's going on now. I do think vaccines are a consideration about, proper medical care. I think excluding that evidence, taking away, that ability of the courts to look at the broader picture, I think is just a bad idea. And however you feel about the COVID vaccine, vaccines in general have been shown to save lives. And so I just don't think that taking evidence away is in the best interest of children, frankly. So I can't support the bill, but I certainly support the piece related to the compact.
Okay. Is there any further discussion?
Yeah, I'm glad you've spoken up. I regret that. I mean, it is something that I don't want to vote against, including vaccination as part of evidence of wellness.
This is not saying we don't agree with vaccinations. This is saying we agree it shouldn't be used to determine whether they're good parents or not. So don't misunderstand my intent as saying that I don't believe children should be vaccinated for many, many things, because I absolutely do believe they should. I do not believe that this is just cause for termination of parental rights, and that's why I supported it the way it is.
And I agree with that too. It shouldn't be, what is the basis of the termination. I agree with that. It's just removing even from the conversation about whether the child, has had the proper medical care. I agree. It shouldn't be the basis, but I also don't think that we should be removing evidence from the conversation. So I think, we can just agree to disagree on that one.
Yeah, we can definitely just agree to disagree.
Agreeably, Senator.
Of course, always. There's always tomorrow.
Okay, so we have an ought to pass as amended motion on House Bill 1820. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
Yes.
Yeah, it would be no.
No.
Okay.
Yes, I'm opposed.
Okay, I'll take this one, Jenny. Okay, Jenny, just, we'll have to get a committee amendment which blends those two together.
Madam Chair, I would like us to consider when this goes to the floor, maybe dividing the question so the Senate could show a really strong position on the compact.
Yeah, okay.
And get
that's fine.
a unanimous vote on that piece.
Yep, we can do that.
Great.
Just
we
remember
remember
to, make sure to
I
let
figured you guys
folks
would do
know.
that.
Jenny will remember that.
Yeah. Oh, there you go.
Okay.
Okay,
We'll do our
next,
best.
we have House Bill 1382, an act relative to the resumption of shared parenting and the determination of parental rights and responsibility.
I move ITL.
Okay, we have an ITL. Is there a second?
Yeah, find it.
Senator Khan, do you move, you second? Okay, discussion on the ITL motion.
I think, of course, I think as a parent myself, having both parents in a kiddo's life is ideal. But there are certain circumstances where it's not ideal. And I think the way that the law is now is focused entirely on the child. And I think, shifting that, what's been law for 15 years, puts children in the middle of parental conflict. And I don't think that's appropriate at all. So I think it's working now. There is already, we saw the purpose statement of the law. There's already a presumption that shared parenting is the ideal. but I'm really concerned about when those cases that it's not ideal, that it'll be difficult to overcome, particularly those situations where there's domestic violence. The piece about domestic violence is, oftentimes it may go unreported because it doesn't want, a parent may not report it, so it doesn't get in the way of the parenting. So I think it is working the way it is. I don't think we need to change it because it's not in the best interest of children.
Okay, any further comments? Senator French?
Yeah, I agree. I don't like the definition of shared parenting with the percentage laid out. I would vote ITL on that bill also.
I think that, first 50-50 and then 65-35. I mean, the courts are the ones that are going to look at all the evidence and make the determination. I think 50-50 in an ideal world would be great, but I think that sometimes, in fact, I think quite a few times, it just doesn't work. And we have to remember, this is in the best interest of the child. And we have to listen to the children as well, who find themselves torn between two parents. So I agree with my friend from District 15 that I think that we have a system that's working. As with any system, we can always make improvements to it, and I think we continue to do so. But the basic premise is that each parent deserves or should legally have their child 50% of the time, I think is difficult to do. Okay, so are there any further comments on the ITL motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Okay, Senator French moves consent, seconded by Senator Whitley. Okay, is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, we'll do this the same way we've been doing this. It'll be mine. Okay, next we have House Bill 1416, an act relative to consent for mental health treatment in parenting cases with shared decision-making responsibilities.
I'd like to make a motion of interim study.
Okay, Senator French moves interim study. Is there a second?
Yep.
Seconded by Senator Gannon. Okay, Senator French.
I like a lot of this, but I think it needs some fine tuning, and we really don't have time this year. So if we interim study it, we can bring it back stronger and better than ever.
Okay, Senator Whitley.
Yeah, no, I appreciate the intent of this. I am a little unclear why it's necessary if there's already a shared decision-making plan in place. Why would we need this, right?
Okay.
Or is it that, here's the thing, maybe it could be a shared decision-making plan that requires both parties' consent. Of course, I want children to get into treatment, as much as anyone else, but is this the way to do that? I'm not quite sure.
Yeah. Senator Gannon?
I was just gonna say, I don't like giving one party power over the other party. I didn't like that one member of the family got to make the ultimate call, and the other had no say at all.
Right, and I don't think it's conducive to shared parenting, especially if you set up a situation where one parent says the child needs mental health counseling and the other parent doesn't agree, and then they go ahead with it. I think that can cause problems within the family. It has to be a joint decision. I just really didn't hear any compelling testimony. I don't know about you folks, but, I asked who determines that the child needs mental health treatment? And what type of mental health treatment? And that can take you down a really dark path.
Right, and I'm wondering if this bill came about because there was a situation where one parent didn't consent to mental health treatment. But we didn't hear that as a
No,
basis, unfortunately.
We didn't hear that because the sponsor of the bill was not available. So.
So the motion is?
Interim study.
Okay, so we have a motion of interim study that has been seconded. Are there any further comments or questions on House Bill 1416? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Move consent.
Okay, Senator French moves consent. I know.
Second.
you are. Seconded by Senator Whitley. Okay, is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Sharon, would you take that up, please?
I am in anticipation, Senator French.
Buddy the first time, buddy the 200th.
Yes. Next, we have House Bill 1118, an act relative to the determination of parental rights and responsibilities following the death of a child's parent or guardian.
I'd like to move on to pass.
Okay, Senator French moves on to pass, seconded by Senator Gannon. Okay. Are there any comments or questions about this bill?
It's
Well, it speaks for itself.
Yeah, I think it did it, yeah. It's worked out well. So we have a motion of ought to pass on House Bill 1118. Is there any further discussion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for consent?
I move consent.
Senator Khan.
And I will
moves consent,
second that.
seconded by- You know, I'm gonna have to sit back here now and watch the hand signals. I feel like I'm at a baseball game. or something.
Exactly. Steal third. Grab the call.
Oh, okay, so we have consent that's been moved and seconded. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, Jenny, once again. Okay, next we have House Bill 1303, an act relative to causes for absolute divorce. Is there a motion?
I absolutely love this bill, so I'd like to move ought to pass.
Okay,
Second.
Senator French moves on to pass.
Absolutely.
Senator Khan seconds. Is there any discussion? Okay. At least it takes the word drunkard out of our statute. That's a good thing. So, okay, so we have an ought to pass motion on House Bill 1303. Is there any further discussion on the motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay,
I move consent.
okay, Senator Whitley moves consent.
And again, and seconded it.
Oh, okay, so
Well,
we
you
have,
just mixing it all.
we have consent on to pass, Senator, consent calendar motion, Senator Whitley moves, seconded by Senator Gannon. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, this is mine again. Okay, the next one we have is House Bill 1305, an act relative to temporary alimony.
I move interim study.
Okay, we have a motion of interim study.
Second.
Seconded by Senator Gannon. Is there any discussion?
I would just say this bill would be a pretty significant change. We received a letter from Attorney Hastings, who practices in this area, who had a lot of respect for, really knows the ins and outs of this issue. And, before we make this big change, we really want to think about the unintended consequences. So I don't think this is ready to go.
Any further discussion? I think we're all. Okay, we have an interim study motion. All in favor say aye.
Aye.
Any opposed?
Move
Okay.
consent.
Second.
Senator French moves consent, seconded by Senator Whitley. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Jenny, this one is mine as well. Okay, now we just have to take up the bills that we have left. The first one we're going to take up is House Bill 238, an act prohibiting provocations based on a victim's actual or perceived gender, gender identity, gender expression, or sexual orientation from being used as a defense in manslaughter cases.
I move ought to pass.
Okay, Senator Whitley moves out to pass. Is there a second?
Second.
Seconded by Senator Khan. Okay. Is there discussion?
I think this is an important thing. This passed the House. I think, it is a particular tenuous time for this community feeling safe. So, I think we did get to think through the issues a little bit. Certainly need a particular piece in there to maintain the constitutionality. But I do think this is an important thing for us to include in our criminal code. Yeah.
I have a question, Senator. Are we not eliminating an affirmative defense?
Are we
So
not,
I initially-
eliminating an affirmative defense?
Yeah, are we not if we pass this legislation?
We're not eliminating
Or-
affirmative defense.
Someone charged with murder is not going to be able to plead a lesser offense is what we're going to be doing, correct? And I just, not that I.
No.
I hate taking a tool off the table for a defense attorney, even though I initially thought I would have no problem with this bill.
Okay. We have to, Senator French walked out for a minute. We're gonna have to wait till he comes back. So is there any further discussion on the ought to pass motion? Okay, the committee will be in recess for 2 minutes. Well, Senator French comes back. Pardon?
Sarah, can you turn your mic on, please?
The committee will come out of recess. We have a pending motion of ought to pass on House Bill 238, an act prohibiting provocations based on a victim's actual or perceived gender, gender identity, gender expression, or sexual orientation from being used as a defense in manslaughter cases. Okay,
So
we
if
all
you-
set?
No, if you were charged with first-degree murder, you would be serving a life sentence. And I hate taking that away, someone's defense abilities totally away from them, even though I think the acts, I wanted to support this bill, I just can't do it.
Okay,
Thank you.
so we have an ought to pass motion on House Bill 238. Okay, is everyone ready? All in favor say aye.
Aye.
Any opposed?
No.
Opposed. Okay, so the
I
ought to
move
pass.
ITL.
Second.
Okay, we have an ITL on House Bill 238. Is there any further discussion? Senator Whitley?
You don't have to.
May I ask that you withdraw your motion and do an interim study? Do you think this is a complicated issue?
That's fine.
It's worthy of conversation.
Ask me twice and I will.
Please.
Yes.
Sarah, can you withdraw your motion?
Yes, I am.
Okay, so is there an alternative
I
motion?
move interim study.
Okay, Senator French moves
Second.
interim study, seconded by Senator Gannon. Is there any further discussion on House Bill 238? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Sorry.
Okay, wait.
Are you good for the interim study or?
I'd rather do an ought to pass, so.
Okay, so
I'm
it
a no.
is 3-2. Senator Gannon, would you like to
Sure.
take this one out? Okay. Okay, next we have House Bill 254, an act relative to the placement of minors in secure settings.
Okay. We ready for this one? This was a complicated one, and I certainly respect and understand what the sponsor was doing. And I know that the sponsor cares deeply for children and, wants to make sure that children aren't in the center inappropriately. My concerns were, I think what I said in last time we discussed this bill, was that we didn't want to have any unintended consequences for the bill. It needed a little bit of cleaning up. We want to make sure that kids, if they get in contact with the juvenile justice system, that they actually get into the system of care. So we want to make sure that. We also, there are many times where a child, may be charged with something and then plea down. And I think that is an important thing for children to have available to them. And then there's the issue of children with disabilities. So Senator Bradley drafted an amendment, and there were a couple of things that I found problematic about it. So what I can do is just sort of describe describe current law, describe what the original version of the bill did, what Bradley's amendment did, and what mine did.
Okay, so we're reading for 2 amendments.
I would like to submit my amendment first.
It's bringing for her amendment 1827.
Yes.
So we have Senator Whitman.
Okay, so.
So it's move, do we have a second? I'll second that.
Thank you. Okay, so folks may remember that many years ago, maybe 5 years ago, the offenses were limited for what it was permissible to commit a child to the Sununu Center. And that's why we have seen the reductions in the census. That was a good thing. Because what we wanted was those minor offenses to get into treatment. So but current law now also has this 3 strikes rule. And that 3 strikes rule allows a child to be committed for perhaps a lesser offense if there are 2 prior offenses. So that's what we're calling the 3 strike rule. That's current law. The bill that came to us from the House, 254, it eliminated the 3 strike rule, which I think people had some concerns with. We heard some concerns from prosecutors. We heard some concerns from Representative Lynn. So Senator Bradley's amendment that he initially drafted returned the 3 strike rule. But what I had a problem with is that it allowed children to be committed to the Sununu Center for simple assault. So my recommended compromise and what you have before you in 1827 retains the 3 strike rule. Okay. So that means courts can commit kids to Sununu Center for Class A misdemeanors if they have been adjudicated delinquent for 3 other offenses. You got it?
Mm-hmm. So it's 4 strikes.
It's essentially 4 strikes, right? But they have to have that 4, right? Exactly. You're right. But my amendment removes the provision that would allow commitment for a single simple assault. So that's the compromise there. And I think that's important. So the additional thing it does is it deals with that concern that many attorneys had that represent children about the need for some kids to plea down from felony charges. And they plea down in exchange for agreeing to serve some time at the Sununu Center. So, and I think lastly, the important protections, so you'll see in the amendment how we retain or we add some language about those plea agreements. So I think it's a balance. I think we are allowing children to, if they need to go to the Sununu Center, right, for that 4th strike, it's going to happen. But I do think I do not think it's appropriate for a child to be committed to Sununu Center for the duration of their minority for just a first time, simple, single assault. So I think I'll stop there and see if folks had questions. We do retain the provisions that connects the the child to the care management entities, which are the part, those are those entities that connect children to the system of care. So this also relates to Senator Carson's bill last session about making sure that we're assessing children and getting them into treatment if that's the real source of their behavior rather than just putting them in kid jail essentially. So I think this amendment really strikes the balance. We're sending the right kids there that need to be there. If there is a violent offense, felony charges, the kid will go there. But otherwise the kid will get in treatment. So I think it strikes the right balance.
So, Senator, sorry, before we go any further, can we just make a reference that Senator Bradley's amendment is 1745S that's been submitted and is available
Yeah,
to everyone?
it's been submitted but not moved.
Okay, and Senator Whitley's amendment is built upon Senator Bradley's amendment. Okay,
Just a question, Senator Whitley. So
Yeah.
currently, how many Class A's is it? Is it just one Class A and a couple minor offenses would put you in?
Right. So as Senator French pointed out, it is actually 4 strikes. So they can be sent to Sununu Center for a Class A misdemeanor if there are 3 prior
Class A's.
charges. Yeah.
okay. Just so everyone knows, the prime sponsor of this bill attached the original version that we had gotten, and it was passed by the House. She has already attached it to a Senate bill dealing with the Lunar Center. So if we pass this, this will be our position when we go into a committee conference. Okay. Any other thoughts? I mean, I'm okay with this. Now, I mean, we had gotten it, and I'm glad that you went and walked us through it, because we just don't want, and I agree, we just don't want to be throwing kids in there for their first offense. We want to make sure that whatever facility it is, because I know there's discussion on building a new facility, that it's serious. And kids aren't there just for frivolous reasons. You're right, the bill that we passed last year required mental health assessment, and because you want to keep kids out of the system. You want to keep them out of the, going from the Sununu Center to the state prison or the county jails or whatever. But I think this is a good step in the right direction, so I will be supporting the amendment. Rick?
I have a couple questions.
Sure.
One is, at juvenile, do the rules of evidence even apply to juvenile proceedings?
No.
It's not clear to me that they do.
Yeah.
And the bill, both bills, the Bradley amendment says the same thing, that the rules of evidence have to apply. And the other section is
I will
on.
say, so on that note, this amendment was drafted in consultation with 2 lawyers who represent juveniles.
I'm also looking at, on page 2, line 1, you're talking about the continuum of care.
Yep.
And juveniles who have serious emotional disturbance or behavioral health disorders.
Yep.
And then it says the minor shall, with the consent of the minor and the
Yes.
minor's family, be referred. Now,
Right,
we
so-
give minors the right to object to consent in
Yep.
context of delinquency proceedings?
So thank you for that question. That's been the subject of a lot of conversation because the system of care. So sometimes we use the term care management entity and system of care interchangeably, but it's not. So the care management entity provides a level of treatment within the system of care. But a core value of the system of care is that it has to be voluntary. So that consent piece is required in other parts of, so 135F is the system of care law. So that consent piece is a core value of the system of care. So it is required for that. I mean, we could say the consent of the minor's family. Okay, I'm fine with that. I mean, but if you have a 17-year-old, they could provide consent, couldn't they?
Well, there's the law about minors giving consent to medical treatment is sort of all over the place.
Right.
But the only time.
It depends on their capacity, doesn't it?
I think it depends on whether the legislature has created a circumstance in which minors are authorized to consent to medical treatment and in other instances withhold medical information from their parents. And the instances are pretty narrowly drawn. Drug treatment, there's the parental consent law regarding abortion that's pretty carefully drawn. There is STD testing. There's only, I don't know, 4 or 5 instances in which minors have capacity to consent to medical care. And I don't know 135F, what's
Right.
built into that. But
that consent language was requested by the care management entities because it's not effective treatment if they don't consent to be there. I mean, I think I would be fine with taking out with the consent of the minor and just doing with the consent of the minor's family. And then I don't feel strongly one way or the other on that one.
So
I don't want them to hold it up.
You're looking at on line 1, saying with the consent and crossing out the minor, and you have of and it will say with the consent of the minor's family. Is everyone okay with that?
Yes.
Okay. Okay.
Do you want I'm sorry, before we do that, do you want to look up that reference? So you can see that it's referenced in the amendment. Oh, good. So, but if you look up, the reference I'm referring to is the 135F43. That's in the amendment, line 2 on page 2. That might answer our question.
Always happens late in the
We're all
day.
gonna tip over.
Oh, we have 1, 2, 3, 4, 5, 6 left. I think. Yep, we have
Do you have
6.
Bradley's amendment?
Mm-hmm.
it doesn't look like it says one way or the other.
So Bradley's amendment also has with the consent.
Yeah.
It has that, and the Bradley Amendment has the evidentiary hearing.
Yeah, it's the same sentence.
So, right. Do you have an idea, position about that? Can we ask Marissa if she has a thought about that?
Yeah, come on up, Martha. Yeah,
So this is an email that came from Representative Lynn, which is that the evidentiary rules, and I asked the question in the wrong way. I asked if it applied at the adjudicatory hearing, but this is the dispositional hearing. And at the dispositional hearing, just like an adult sentencing, the rules of evidence don't apply. So Representative Lynn's suggestion was to strike out which the rules of evidence have been applied from the sentence.
What line are you?
I'm sorry, it is line 26 on page 1 of the Whitley Amendment.
At which the rules of evidence have applied? So just strike at which the rules of it. So
If I may?
Yeah.
I actually know a lawyer who's been before this committee that just had one of these hearings today. I can run out and call him really quickly.
I think that would be helpful just to, because I think we want to get this right in this
Yeah,
committee.
we've got to get it right.
I am fine with taking out the consent of the minor. I'm fine with that. I do want to just sort of get this right on the evidentiary piece.
So the
Marissa-
evidentiary piece and then consent of the minor or the minor's family, maybe?
Yeah.
I will run out and call and be
Okay,
right back.
so the pending motion on House Bill 5.
So we won't have a pending motion because we're going to be doing a different, an amended amendment.
Okay, so we're just going to set this aside while we figure this out. What? What's better?
We should just table it.
Can we just?
We can just move on.
We don't?
Yeah, all right, we can come back to it, but we can also just table it, interim study it.
Yeah.
No, we can't have that.
On the issue of the minor and the minor's family, at least currently in the statute, all the references to the consent is minor and minor's family. 169, same statute. No, I'm sorry, no, 169B19, or 169B, sorry. So 169B19, dispositional hearing currently refers to the minor and the minor's family.
Okay, good.
So you're consistent, so you can keep the end.
Thank you for that. So it would be, so leaving in with the consent of the minor would be consistent with the others.
Statute.
Consent to the minor.
Yeah.
Okay,
Consent to
perfect.
the minor and the minor's
Okay,
family.
thank you. Thank you.
Okay, so that one's taken care of.
That one's taken care of.
Find out about the
So it's
eventually.
okay as it was.
Yeah,
Correct.
we're good, but we're gonna, because I think we've all agreed with something like this, we need to get it right.
Yeah.
Okay, the next bill that we have is House Bill 1101, an act relative to a forfeiture of personal property. Is there a motion?
I move on to pass.
Okay.
We
Senator
we
French,
went to 11.
1101.
Okay,
Yeah,
good.
we're just gonna skipping around a little bit. Okay.
We didn't
Well,
wanna do-
we're on another bill. Come back.
Didn't want to do 408.
So Senator French has moved ought to pass. Is there a second? An act relative to forfeiture of personal property.
Apparently that wasn't a popular motion.
No. Okay, then I will move interim study.
Second.
Seconded by Senator Gannon.
Sorry.
Okay. So this is from Representative Silva. This language is included in House Bill 1296 and House Bill 331. They want us to basically, there's a federal program of equitable sharing. It limits the conditions under which seized property may be transferred to a federal agency. Is there any discussion? Okay. All in favor, say aye.
Aye.
Any opposed?
So
Okay, so it's 4-1. Who
I'll
would,
take it out.
no, you,
Oh, that's right, I can't. That'd be helpful.
I understand this. I'll take it
okay,
out.
Senator Gannon will take this one out. Okay, you're just gonna throw me there for a second. Okay. Where did Marissa go? She walked out
She
again.
went to call one more person.
Okay. Next, we have House Bill 408, an act relative to employment restrictions for registered sex offenders.
Oh, right.
Is there a motion?
I move ought to pass on amendment.
We don't have an amendment number, we had two proposed.
Yeah.
I'll move ought to pass and then propose a committee amendment. Then.
The one non-formal amendment was from Representative Lynn, and the other was from Representative Revelle.
Right.
My interest in moving the ought to pass is to consider then Representative Lynn's amendment.
Yep. Did you move it?
What I don't understand is why this wasn't amended in the House.
Right.
Why didn't they amend this in the House?
I think we ought to interim study it, but let them work
Yeah,
on
I
it.
mean, we've got multiple amendments coming in, one from the sponsor, one from someone else. Obviously, the bill needs work. You want to try to figure this one out or just say,
No, I'd send it back. Interim study.
interim study it and then just, hopefully they'll come back with it next year and everyone will be on the same page.
Okay.
Okay, so we have a motion. Is there a motion for interim study?
So wait, second.
Okay, moved by Senator French, seconded by Senator Gannon. Is there any discussion on the interim study motion?
I think it's definitely worthy of consideration.
Oh, I
think
do-
you're
I do
right.
too.
Well, I do,
We
but
do- we-
not this form.
Right, there's a balance
Yeah.
between, making sure people can make a living and also keeping kids safe. And I think we have to strike that right balance.
Right, and it just doesn't, it's not ready to move forward. So we have an interim study motion. Is there any further discussion on the interim study motion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Senator French moves consent. Is there, seconded by Senator Khan. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny? Okay, next we have House Bill 1103, an act relative to certain assets in a divorce proceeding.
Move on to pass.
Okay, Senator French moves on to pass. Is there a second?
Second.
Okay. So we had no one who opposed this, and this bill provides that in a divorce proceeding, the court shall not require a party to sell a marital asset if the party is able to compensate the other party for his or her interest in it, and the sale is not required for an equitable division of marital property. I think it's pretty self-evident.
We'll do my amendment after.
Oh, yes.
Do we
Oh,
need
well,
the amendment first?
we should do your amendment first. So we have an ought to pass on the bill, but you have your amendment. What is your amendment number?
It is 1303S.
Okay, Senator Gannon has amendment 1303S. Is there a motion on 1303S?
Move ITL.
Okay.
Oh, because I won't give you some.
Okay, so is there a motion on amendment 1303S?
Ought to pass.
Okay, Senator Gannon moves on to pass. Is there a second? I will second it. Okay. So, Senator, talk us through your amendment.
It was, someone asked me to bring this forward. They just really wanted to include animals, so people couldn't be nasty in a divorce when they're splitting up property. Just like the core of the bill, if you can afford the asset, you want to be able to keep your Indian bike, and if you can afford to buy your spouse off, that should be good. So too with the animals, would like this to be a fair division, and it was just about the animal, Senator Khan.
Senator Khan?
A question for you, Senator, is the second sentence in 22A. That is very specific to just this section. It does not pertain to any other section in 458.
No, because Senator, if you read it,
I
it says, in such case, the property settlement shall address the care and ownership of the party's animals, including, taking into consideration the animal's well-being. So they're only speaking about the animals per se.
At the second sentence, upon petition of either party, right?
Yeah.
Yep.
That sentence only applies to
This paragraph.
and the agreement relative to animals.
Yes.
You could say modify the property settlement. Oh, yeah, exactly. No, it's good. It only
If you folks think divorces are messy and long, this will do nothing but extend the fighting between two parties for years and years and years. That's why I'm against this. And children will suffer from it.
Okay.
So, I wonder then, in light of that, if the person making the motion, and or I can ask Senator French, I mean, if the second sentence wasn't there, is your objection disappeared?
From where to where, Senator Khan? I'm sorry.
If upon the motion, upon petition, if that is the reason why Senator French is.
That's the entire amendment, though.
Yeah.
Well, what's the definition of tangible property?
Something, I believe it's something
That's current law right now, right?
It's current.
That's a
Yeah.
tangible property?
But,
So
you
the
know-
second line is what's added?
The
So if we
7
strike-
and 8 is what's added.
Right.
So if we strike 7 and 8.
That's
would
the
I
whole
be happy?
amendment.
Yeah,
Yeah.
right, I'd be delighted.
Why?
Because it would be an ITL, nothing would pass, nothing would change. This is
Well,
gonna
we'd be
create
back to the
huge
original
fights.
motion.
The problem is that, you know, a lot of people nowadays, their pets are their children. You know,
Then
that's how
can
they
sue
view
for
them.
Hospital bills, they can sue for dental bills of their pets, they can sue for visitation rights after it's all done. This is just gonna be nothing but more contention between the parties.
Senator, I think I see your point, but all of that would be settled with just by transferring ownership of the pet. And they can do that now already. I sign away my rights.
Oh, yeah,
But during a proceeding,
oh,
they can sign away their rights to the pet and that's it. It's done and over with.
yeah, you can vote for it and
Yeah, I
listen
mean,
to people complaining in years to come.
oh, they're gonna complain anyway. Senator Khan?
Senator Khan, is your hand up or you just resting it?
No, I think he wants to say something.
It does seem strange to only be able to modify the agreement as to animals. We are sort of carving out animals as something that you can just go back and relitigate.
Forever and ever. and
I do
ever.
see that. I mean, I agree with Senator Carson that it is only related to this one, to animals. But why are we gonna create a carve out where they can just relitigate animals?
Right, they can also put in their divorce decree that they can relitigate afterwards if they choose to. Instead of leaving.
I see Rick is smiling. He's laughing at us going around and around
Like
and
this
around.
is the most important issue we're discussing this evening.
Might be to somebody.
Yeah, and that's good thing to somebody.
And they'll come in and tell you all about it next year, so.
But they will, I mean, I think it will be addressed in, the settlement. And is it typical, I guess that's a question for the senator. Is it typical for the settlements to allow the ability to go back in and reopen any?
I think a court would probably not want to approve a divorce agreement that isn't more or less final. The courts have a value finality.
Okay, all right.
I do think it's a little strange that we are choosing just to carve out animals in this case. I understand that animals are the world to people, but we are doing a carve out with this amendment that they can go back and relitigate this issue. I see how that could be a problem.
No, I get it. It's just, it's animals. And we know how animals can get used in, nasty divorce cases and
Oh, yeah.
so on and
For
so forth.
years
That's
and
why
years and
and in
years.
domestic violence situations, we passed a law a few years ago concerning animals. And you don't want to see an animal being abused and not taken care of.
No,
So.
Which is almost an argument not to do this.
correct.
Okay.
Yeah, in fact, I think it says here, August 24, 2019, this became effective.
Okay. So.
It feels like we're reaching consensus that this is not a good idea, this amendment.
Is there any further discussion on Amendment 1303S?
I guess I'd just say,
Still bring this forward?
Yeah, I'm still bringing it forward.
Okay, so
yeah,
he's still bringing it
and
forward.
I think Senator brings forth something and can go back to his constituents and say, this is pretty well addressed in current statute, that
Okay.
tangible property, including animals, are being taken care of, taking into consideration in the settlement. If that's disputed, then it will be taken care of in the settlement.
Okay, so we have an ought to pass motion on Amendment 1303S.
Go for a smoke.
Is there any further discussion? Okay. All in favor say aye.
Aye.
Aye. Oh, Phil and I. And no?
No.
No.
Okay, so we lose, Phil. There goes. So the amendment 1303S fails. We have the underlying bill. I believe there's an ought to pass motion on the underlying bill. Is there any further discussion on the underlying bill? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, 5-0. Is there a motion for the consent calendar?
moved.
Yeah, move consent.
Okay, Senator Whitley beat you to it, so
Well, it's okay.
So we have moved by
second it.
Senator Whitley, seconded by Senator French. Is there any further discussion on House Bill 1103? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, this one's mine too.
I think we can go back to 254 and maybe if Marissa doesn't
Okay,
mind coming
Marissa,
back
you
up.
want to come up and talk to us about this? If we're going to pass this, we need to get it right.
So there's two questions. One is this issue about when the rules of evidence apply for juvenile proceedings, and then the second issue, I think that we have resolved, is the consent issue. So on page 2, line 1, we have, it sounds like it is consistent with existing statute to retain the consent of the minor and the minor's family. So if you can share with us what you know about evidentiary hearings.
I just learned something.
Okay.
For the record, I'm Marissa Chase with the New Hampshire Association for
You're
Justice.
not on the record.
Oh, sorry.
Nope, this is exec session.
Excellent.
So,
So I just spoke to Michelle Longren and Karen Rosenberg from the New Hampshire Legal Assistance and Disability Rights Center, respectively. And I know that Richard Head is outside on the phone with Judge King. The rules of evidence only apply to evidentiary hearings. They do not apply to dispositional hearings, which is essentially a sentencing hearing. So just like in criminal court.
Rules of evidence apply to the adjudicatory hearing.
Adjudicatory hearing. I'm glad I told Rick first. And then the consent of the minor and the minor's family is in current statute, but if that were changed to an or, that would also be okay with those entities that know more about this than I do. But it is in current statute as is.
Okay, so just to say it again, the rules of evidence apply to the adjudicatory hearing, but not the dispositional hearing. Okay, so then are we okay with leaving it in here?
No, you have to take it out.
Okay.
okay, so we are striking on page 26. Where would we start here?
Okay, so what Attorney Lehman is saying is that we need to strike it from here because what we're referring to, because we're talking about confinement. So that's
We're talking about the dispositional hearing, right? Because by section number 5 up at the top, it says we're in the dispositional hearing, section 19.
Yeah.
And then on line 26, should read stipulation by the parties or a hearing.
Or a hearing. Well, and then period.
Period.
And an evidentiary and at which rules of evidence have applied?
So the sentence will say stipulation by the parties
or
a hearing. Attorney Head, does that, okay.
You take that.
Thank you.
Thank you.
So I spoke with Judge King and one of the court administrators, and they would take out the word evidentiary in that line, and then at which the rules of evidence have been applied would be struck.
So then, okay.
No, go ahead, Senator Whitley.
Because, okay. So in the prior line, we were saying if it is made by clear and convincing, so they can still provide evidence even if it's not if the rules.
And that's what, you could have an evidentiary hearing at which the rules of evidence do not apply.
Got it. Yep.
And the reality is they fold together sometimes.
Yeah.
So you've gotten all the evidence. Sometimes it's just argument at that point.
Yep.
So there would be evidence and argument that would be taken into consideration, but it's not necessarily an evidentiary hearing at that stage.
I would assume that the juvenile has the right to present evidence as well, the constitutional right to present evidence at the dispositional.
Yeah.
Do we need to move a committee? All right, so I move a committee amendment as we just described.
Okay.
Does anyone
So
second
this
that?
will be a new committee amendment with the language beginning on line 26. We're striking out from or. We're going to start at or. We're crossing out and it's going to become an A. We're crossing out evidentiary, And we're going to include the word hearing. There's going to be a period after the word hearing. It's the end of the sentence. And we're crossing out at which the rules of evidence have applied. We're crossing those out.
And we're retaining page 2, line 1
Yes,
as
and
is.
we are going to retain on page 2, line 1, with the consent of the minor and the minor's family. I think we got it. I think so. So, I will second. Okay, so we have a motion to pass on the committee amendment. It's been moved and seconded. Is there any further discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion on the bill as amended?
I move on to pass as amended.
Okay, Senator Whitley moves up to pass as amended. Okay, is there a second? Seconded by Senator French. Is there any further discussion on the bill as amended?
I think this strikes a really good balance here, with public safety, with making sure the right kids are going to Sununu Center and making sure kids who need it are getting to treatment. I think it's a delicate balance and we've reached it. For the nose.
Hit it someplace.
Where the chase?
Okay,
Strikes is a little.
so we have a motion of ought to pass as amended. Is there any further discussion on the bill as amended?
4 strikes is the stretch for me, but I'm gonna let it go.
Okay,
It's a lot of strikes.
that's a lot.
It's a lot.
Yeah, I only allow 3 usually, so 4 is too far for
It's
me.
the
but-
fourth time, really. So, okay,
Yeah, but I just want to say on the 4th strike, it's a misdemeanor, right?
It's also the case that the way it's written, or at least the way I'm reading it, which and I'm happy to be proven wrong, if a juvenile is found to have committed 3 offenses in a single incident,
Yeah.
that the second
Ooh, I like that.
circumstance could be the 4th strike.
That's correct.
Oh, okay. Thank you for clearing that up.
okay. So we have an ought to pass as amended motion. Is there any further discussion on the amendment? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Move consent.
Okay, Senator French moves consent. Is there a second?
Second.
Seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, I'll be doing this one as well.
And that, the scenario you discussed is when kids plea down. There's the balance. Okay.
Okay, next we have House Bill 1178, an act prohibiting the state from enforcing any federal statute, regulation, or presidential executive order that restricts or regulates the right of the people to keep and bear arms.
And move
Motion on
ICL.
pass.
Okay, wait a second, both at the same time.
I heard William first, I'm sorry.
Okay, so we heard
I appreciate your honesty.
Gannon ought to pass. Is there a second?
A second.
Okay, second. We had this one last year. And I don't know what happened to it, quite frankly. I don't remember.
This is different than last year. So this is, I think the Senate position last year was future orders. This expands that to prior as well. So it is different than last year's Senate position. What I'm mostly concerned with, there's a lot of problems with this, but we asked the state police officer if this unintentionally would create a situation where New Hampshire would be the go-to place for these ghost guns that we're hearing all about, because they wouldn't be able to do anything about it. And so if we have the state police telling us that this is going to create a potentially gun trafficking situation or mecca, I just don't think that we want to do that. I think this bill, clearly is anti-public safety. It's going to make us less safe. Law enforcement is not in support of this. I think we have very strong protections in New Hampshire, both in our Constitution and, of course, the U.S. Constitution. I don't think this bill is necessary. This is not about protecting gun rights. Our Constitution does that already. This bill is going to make us less safe.
Do you know what ghost guns are, right?
Yes, I do.
Tell me.
It's the right. And so the problem is it's these, right? So they can have these kits, right?
They have these kits. So a gunsmith,
Yep.
and I have friends who build their own guns. The only reason and that's not unlawful, the only reason, and ghost guns aren't unlawful, but they make this name up of ghost guns. It's just because they don't mark the
Serial
receivers
numbers.
with any number.
Right.
So it really doesn't matter because
They're sold in kit form. Right?
once they make the gun, they assemble and make the gun and the receiver and everything. Just because it's not numbered doesn't make it more dangerous or trackable or anything else. It's just a gun.
Well, no, I understand that, but they come, my understanding is that, so they come partially assembled and they are exempt from background checks.
They are because you're buying pieces.
Right, exactly.
You don't buy, so receiver is just a piece of folded metal.
No, I understand
I
what
know
it
you do.
is. I understand what it is.
Just, I don't want you to get confused here.
I'm not.
Okay, so
Yeah.
is it unlawful to carry a receiver with you?
I'm not talking about what's lawful or unlawful.
Is
I'm
it
saying that this little sort of loophole allows people to get guns without a background check.
If they know how to make them.
It's just not a situation that I want to encourage. We heard from the
Okay.
state police that this is a
I
problem.
just wanted to make sure you knew it.
Yeah, yep.
Yeah, and it doesn't need to come in a kit either. These can be reverse engineered, manufactured synthetically. Could be done at any college campus that's got these machines that will replicate an existing product. And, you know, I think that when I heard from the state police that they were concerned that should a state law, should a federal law prohibit that kind of manufacturing, that it would get in the way, that our noncompliance with that could interfere with some federal funding that our state police would be qualified for. That tipped me to oppose this. So I'll be voting against and not to pass on this.
The other piece I did want to mention is that, we heard some testimony that because public records, criminal history can only be reported by state officials to federal authorities, that means that civil records like domestic violence restraining orders or records related to involuntary mental health commitments, both which prohibit firearm ownership under federal law, our state folks can't share that with federal authorities under this bill. I think that's a real problem. So that means it's going to be easier for violent domestic abusers or those with very serious mental health issues to have access to firearms.
So this is about guns.
Okay, wait a second. We need to get,
Make sure for informational purposes only, and I see Richard over there, that the judicial branch did propose an amendment. For informational purposes, they did propose an amendment.
okay, we've been, yeah, please, I looked through, I don't think I have
It
one.
looks like this. It looks like just a copy of the bill, and then it's red language on the back that
Oh,
deals
okay,
with
you're right.
Senator Whitley's comments that addresses that.
The second one, not the first one.
Yeah, because I am looking and I don't have that.
I have extras. Does anyone else need it?
I gotta see if I have it.
It's a good amendment.
Yeah, I don't have
It
it.
was,
Where is it?
it was
I would
handed out
move-
during the.
I would move the
Right
committee
there,
amendment.
right there.
That's it?
Page. Yep, flip it over and it's in the red writing.
I think I need that, Jenny.
Thank you.
Sorry, I think I need that.
Yeah, I never got that, so that's why I'm like, what are we talking about? Okay. Let's see.
Okay.
Nothing,
Senator Khan moved it and I second that.
Okay, so we are now talking about a proposed amendment to House Bill 1178. And it is proposed by the judicial branch, and it says, nothing in this chapter shall prohibit the judicial branch from entering protective order information into law enforcement databases.
Well, this addresses one of the objections that was heard in the hearing.
Yeah, not all. So I certainly support this amendment. It doesn't address everything, though.
No,
So you're in support of the bill if that amendment's on it?
No.
I'm in support of the amendment.
Support of the amendment. It only addresses one concern.
So you're yes to this and no to the ought to pass on the whole entire bill?
Correct.
Okay.
So Senator Khan, you moved the amendment.
I second it.
Okay. What I'm looking at begins on line 23. Nothing in this chapter shall prevent a state, county, or local official from approving authorized federal officials upon their request with official state, county, or local records that are available to the public or which constitute criminal history records maintained by an agency of the state, county, or local government, or taking any other action necessary to fulfill or comply with the state's obligation under the National Crime Prevention and Privacy Compact. Wouldn't this, being able to enter protective order information into law enforcement databases, isn't that covered?
The concern we had was civil domestic violence orders as opposed to criminal. So that it's unclear is the short answer, but the National Crime Prevention and Privacy Compact, we don't think would cover a civil domestic violence order and entering a civil domestic violence order in the database. So we just didn't think that exception would allow for it.
Okay, concern civil.
And as I said in the testimony too, we are not 100% sure this is absolutely necessary, but we couldn't read this and say definitively we would be able to continue to enter in civil domestic violence order into the database.
Okay. Okay, so that's the reason for including this language. So we have a proposed committee amendment that would include, I'm not sure, Jenny, just exactly where it would go, unless it's at the end of section.
The end of the paragraph, so line.
Right, okay. So it would say, nothing in this chapter shall prohibit the judicial branch from entering protective order information into law enforcement databases. So that is the proposed committee amendment.
And all the rest, right?
Pardon?
Yes, I understand.
Okay. So is there any further discussion on the committee amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Nay.
Okay, so it's 3-2, it passes. So now we have the underlying bill of the committee. Is there a motion?
Move on to pass.
Okay. Senator, as amended.
As amended.
Okay,
Thank you, Jenny.
Okay, so there is a motion of ought to pass as amended. Is there a second?
Yep.
Seconded by Senator Gannon. Is there any further discussion as amended, as on the bill as amended?
Yeah, I just wanted to make it clear that this is going beyond the Senate position from last year.
Okay. Okay.
And I want to make it clear that everyone voted for this once. Thank you.
Okay.
Yeah, we
So
didn't.
we have.
We didn't support it last year. We did not support this last year.
You didn't?
It was the majority's position. We did not support this last year.
Did you vote on it just now?
The amendment.
Yeah, okay, so you voted for it, okay.
She said we voted for the amendment.
Yes, he's being a silly. Okay, so we have the motion about to pass as amended. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
No.
No.
Okay, so it's 3-2. Senator French?
Sure, I'd love to.
Yes, I know you would. Okay, next we have
Jenny?
House Bill 1266, an act relative to restrictions on enforcement of federal immigration laws.
I move ITL.
Okay, can we have a softer landing of?
Sure. I withdraw. I move.
Interim study?
I second.
Okay, so we have motion of interim study moved by Senator Gannon, seconded by Senator Whitley. Is there any discussion on the bill the interim study motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Okay, Senator French moves consent. Is there any discussion? Seeing none?
Oh, second?
Oh, I thought there was, okay. Consent, calendar motion? Any further discussion?
We are just behind that. We're good.
Okay, we're good. Okay, seeing no further discussion, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, this one's mine as well. Okay, last bill, folks, last bill, I think so, right, Jenny? Okay,
Wow.
last bill.
Just before you start this, I'd just like to say thank you for a wonderful job this year.
Oh, I look,
The
you've
final
done
bill.
it without all of you.
Final bill. You've done wonderful.
I do want to second that. This has been an extraordinary amount of work, most of which has been shouldered by you and Jenny. And I'm truly grateful that you ran this committee with such efficiency. You made everyone feel listened to, both committee members and members of the public. So I do second that the chair really needs to be commended on great work this year.
Thank you, and I just want to, I'd just like to say, I couldn't have done it without all of you, and especially Rick and Jenny, that really kept us focused on and moving forward. Just really can't thank all of you enough. We were given, I think we had the majority of all the bills came through the Senate this year. And with all of your help, we got all the work done since the last bill.
I thought Senator Khan was going to be such a pain, and he turned out to be such a charming fellow mate on this.
We better.
Take that as a compliment there, Senator.
Go put it on.
But it's going to be up on YouTube, Senator Khan, so you can constantly replay it.
Yeah, exactly.
I do, and I also appreciate, I mean, I have to say, well, we're
Turn it
just
into a
giving
5
kudos.
minute.
We have,
I would.
in this committee, we have the hardest issues. I really do
Yeah, we
think
do.
they are the most controversial, and I also thank my committee members for, again, making everyone feel heard, for, freely discussing the issues. We can disagree without being awful to each other, and I think that's huge, and I'm really grateful for that.
I agree. I think we do face, I think, some of the hardest issues, some of the most complicated issues legally, and we have to get it right. And so we tend to spend a lot of time wordsmithing on bills, and thank God for Mr. Lehman, our attorney, who helps us with our wordsmithing to make sure we get everything correct. So, last bill here, folks.
Woo.
Did we do
Pardon?
5-0 consent?
Yes, we have House Bill 1625.
Motion for it to pass.
No, 12,
Okay, all right, whoa.
Yeah.
We just have a motion of ought to pass on House Bill 1625, moved by Senator Gannon, seconded by Senator French. This bill really reflects some actions that were taken a few years ago, unfortunately. We had a bill in the Senate dealing with buffer zones, and I argued that we should wait because there was an impending Supreme Court case that was going to give us a lot of guidance on the buffer bill. Unfortunately, a majority felt that we should pass it. It was passed. A few days later, it was signed into law. And then we found out the Supreme Court ruled and basically rendered our law unconstitutional. Then Attorney General Delaney issued a advisory, said that they couldn't enforce the law. So all this basically is doing is repealing a law that we have on our books that has not been enforced. I think with another impending Supreme Court decision that's going to be coming out in May or June, I think is going to provide us with more advice on not only this issue, but on the abortion issue as we move forward, so we can craft something that is going to be constitutional and that will protect the rights of women accessing clinics, as well as the people who want to protest. So we've got to be able to strike a balance And unfortunately, the bill that was passed did not strike a balance and is unconstitutional. So we have a motion of ought to pass. Senator Whitley.
So I do have to respectfully disagree. I think that this law was designed to balance First Amendment rights with of course, this other right of safety and privacy. I think, we have only seen an increased need for laws like this, particularly with increased violence around these centers. So the need for this type of law has only increased. I think, getting rid of it at a time where we need it the most, I think is a problem. I think, New Hampshire's law is distinguishable from the law that was struck down by the Supreme Court. We had some, nuanced testimonies that not all buffer zones are unconstitutional. And we had a fair amount of testimony about the difference between the Massachusetts law and our law. The New Hampshire law allows for this discretionary buffer and only enables a health center to create a patient safety zone as the facts and circumstances dictate. So it's narrowly tailored. I think when you're talking about balancing all these important rights, you do have to do that narrowly. You have to design it in a way that is narrowly tailored, and this law is. New Hampshire, our law is no longer the subject of litigation. It was challenged, but it was dismissed. So I would disagree that, it is unconstitutional, because I don't think it is. I think it was written in a way by very smart people to, walk that line and to balance those. And then I just feel like, we are heading in, not only have we already seen increased violence, into a potentially really disruptive moment in our, national discussion on reproductive rights. We are only going to see an increase in violence. We do know that people are going to those states that have more permissive reproductive rights, and I'm afraid that's going to happen in New Hampshire. And I really think it's such a sensitive time, and I think it's problematic to repeal this law.
Thank you. Are there any
I'd like to
comments?
piggyback on that. I think this is a public safety issue, and I think we are putting patients who are in a vulnerable state into a more vulnerable state. And I really hope that if this passes and the majority, that there is not fault for us to have taken away this protective right. I think that it is important to maintain. And there are states that have been challenged in the Supreme Court where these laws have been upheld. So I totally agree. We are heading into a period of time when public safety should be our primary concern for patients. And I think we're taking away that safety net for them. And I will be voting against this because I just don't think that it's prudent for us to do so.
Okay. Senator Gannon.
I just think the First Amendment right of these people to come and peacefully protest is sacrosanct. I think we heard testimony that people were arrested, and that's great. If they were violating, blocking people's access, there were arrests. That's great. If you do something wrong, there are laws in the books to take care of you from doing that. But the right to peacefully, I think the Coakley case is right on point. And I think this is a content-based restriction. And as Rick knows from my singing, content-based restrictions always fail. So I think, even if challenged in court later, I think that's the reason they have never went to court over this bill, because they know they'd fail.
But we certainly heard testimony that there is harassment and that people feel vulnerable because of some of the actions that people who claim to be peaceful are enacting in these spaces. I think that we're putting people we're creating an opportunity for harm to be done, and if not physical, at least mental harm in places where healthcare is being provided. I think it's wrong.
Okay.
And I will just say that, I think we go on a dangerous path where we hold one right as more important as another. Certainly, the First Amendment right is so critical to our democracy, but it's not absolute, and it's not at the expense of other people's rights. So right here, we're balancing, First Amendment rights with the right to be safe and the right to access treatment and the right to privacy. We do have other buffer zones in place. We have a buffer zone, against campaigning because it interferes with another precious right, the right to vote. So I just think it's dangerous when we, lift one right up over another. The whole purpose of the rights that we are, conferred by the Constitution is that, they need to be balanced against each other, particularly when we're in community with each other and we are, in a democracy. One person's rights cannot trump the other. There has to be a balance. And so I think we do go down a dangerous path when we, choose one right over the other. Thank you.
Is there any further discussion on on House Bill 1625? Seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Yeah, no.
Okay. Senator Gannon, would you like to take this one out? Okay. We are done. We are done. Can I get a motion to come out of executive session?
So moved.
Moved by Senator Whitley, seconded by Senator French.